네, 2024
Welcome to the Seoul Copyright Forum 2024. I am Yeon Hwa and I will be the MC for today. Thank you. It is an honor to join such a meaningful event. I would like to thank all participants for joining us despite your busy schedules. Also, I express gratitude to all viewers who are watching us online. The theme of Seoul Copyright Forum 2024 is Generative AI and Copyright Striking a New Balance. After years 2019 and 2023, this is the third time holding a forum on the topic of generative AI. And such case is unprecedented. It is a testament to the significance of the topic of generative AI globally. And the topic has especially become an indispensable element when we discuss copyright. The previous two forums looked at generative AI as creative tools, relevant copyright issues, legal challenges, and policy responses of major countries. Such process helped us recognize that finding the right balance among various stakeholders is the challenge of the times in the evolving copyright landscape. We will be hearing experiences and insights from experts from home and abroad, from the government, industries, and academia. I hope you will stay with us until the end of the program and add your wisdoms too as we face up to the challenge. I will introduce today's program. We will begin with the welcoming remarks and keynote speech which will be followed with part one, when we will hear policy responses of major countries to generative AI, which will then be followed by part two, which will explore industry initiatives to respect copyright and develop the AI industry, and also legal proposals on how to strike the right balance. Also, we will then end today's forum with a Q&A session and discussion with all of the presenters. Then we will now open the forum with welcoming remarks from Ms. Hyang-mi Jung, Director General of the Copyright Bureau of the MCST. Please welcome her with a warm round of applause.
안녕하십니까?
Good morning, ladies and gentlemen. I am Hyang-mi Jung. I'm the director of the Copyright Bureau at the MCST. I would like to welcome everyone to the Seoul Copyright Forum 2024. There are those who are participating in person as well as online. We have prominent experts as well as the general public. Thank you so much and welcome everyone. This forum brings together many prominent experts in copyright from home and abroad who will be participating as moderators and speakers. Namely, we have Professor Dae-hee Lee of the Korea University School of Law, Mr. Darren Pogoda, Attorney Advisor of the USPTO. We have Mr. Yukihiro Miwa, the Senior Attorney Advisor of the Copyright Division of the Agency of Cultural Affairs of Japan, Professor Thomas Margoni of the KU Leuven from Belgium. And then for session two, we have Mr. Moon-gi Lee, Director of Konan Technology of Korea, and Ms. Sonia Cooper, Assistant General Counsel for Microsoft UK, and Professor Sang-yuk Cha of the Kyungpook National University School of Law of Korea. And last but not least, we have Professor Chun-Nam Lee of the Chungnam National University School of Law, who will be moderating the Q&A and the discussion session. Thank you so much for being here with us today. Let's give all of them a big round of applause. Article 1 of the Korea Copyright Act stipulates the purpose of this act is to protect the rights of authors. And we would like to promote an ecosystem that provides enabling environment for everyone. So we believe that appropriate remuneration should be given, fairness should be ensured, and also everyone who are part of that ecosystem must be respected. And only when these kind of values are ensured can we have a prospering future. So as such, protection of copyright and the promoting the use of copyright are two values that underpin our copyright regime. So the Korea Copyright Act also stipulates this in its law. So on one hand, we need to ensure and protect the rights of copyright owners, but also promote the fair use of works in order to contribute to the improvement and development of culture and related industries. The goals and the values of the copyright regime are being shaken by the emergence of the generative AI, because we are witnessing new forms of the use of copyrighted works and the ways of works are being used. And so the values need to be maintained nonetheless. So we have to think about the goal of the developing of AI technology. The 2024 Seoul Copyright Forum is dealing with generative AI and copyright, striking a new balance. Training and output of generative AI may conflict in somewhat ways with the protection of copyright, and also the policies that protect the rights also have to strike a balance to promotion of the fair use of works. So we need many institutional measures which we will be looking into and discussing at today's forum. Today, many countries around the world in regard to generative AI and copyright are promoting various policies and also putting into a lot of effort and consideration into these issues. Since last year in June, many private sector practitioners have come together with the public sector to form a working group, and in December we were able to publish a guide on generative AI and copyright. So the draft of this guide was introduced to you for the first time at last year's Seoul Copyright Forum. This year, the second round of the working group will be implemented by the Korean government, and we will continue our policy efforts to find that new point of the new balance. Today's Seoul Copyright Forum brings together many prominent experts in order to find that balance between the use and also protection of rights, and also to come up with viable solutions. And I hope that today's forum will contribute to that end. I look forward to your continued interest into the Seoul Copyright Forum, and I would like to thank the Korea Copyright Forum for your hard work in making today's forum a success. Thank you very much.
네, 감사합니다.
Thank you very much. We have heard some welcoming words from the Director General, who has touched upon the relevance of today's forum, the contents, and what we expect from today's forum. Another big thanks to Director General. But before we get started, I would like to introduce the prominent guests. But before that, let's have a photo opportunity. So when I call out your name, please come up to the stage. First of all, Director General of the Copyright Bureau, Hyang-Mi Chung of the MCST. Professor Tae-hee Lee of Korea University School of Law. Mr. Darren Pogoda, Attorney Advisor of the USPTO, please come up to the stage. Mr. Yukihiro Miwa, the Senior Attorney Advisor of the ACA Japan. Professor Thomas Margoni of the KU Leuven of Belgium. Ms. Sonia Cooper, Assistant General Counsel of the Microsoft of UK. Professor Chul-Nam Lim of the Chungnam National University School of Law, Professor Sang-Yuk Cha of Kyungpook National University School of Law, and Yong-Ah Lee, the Director of Cultural Trade and Cooperation Division of MCST, and last but not least, Mr. Moon-gi Lee of Konan Technology. Please come up to the stage. Yes, we have the guests of honor who are the speakers of today's copyright forum. So once we have everyone on stage, we will be having group photos. I think everyone is ready.
Show your best smiles towards our photographer. What a wonderful day. It's not so easy to gather all the experts from the globe to be gathering here all at once. And then we're going to move on to the next pause, which is the Korean finger heart. 네, 여러분 손 하트 아시죠? 깊은 순간을 기념하고자 손 하트를 하도록 하겠습니다. Yes. We're just supposed to make the little heart with your fingers. Yes. Please refer to your Korean colleagues. 네, 큰 미소로 사진 촬영 진행하겠습니다. 1, 2, 3, 김치. 네, 됐습니다. For your cooperation. 네, 여러분 큰 박수 부탁드리겠습니다. 이상으로 해외 또 한국의 국내.
Thank you very much for participating in the group photo. Please go back to your seats. So as you could see from the photo opportunity, we have prominent guests and experts in generative AI and copyright from various parts of the world: Japan, Belgium, the US, UK, and the United States and Korea. Thank you so much for being here with us today. So now I'd like to start the Seoul Copyright Forum 2024. We'll be talking about generative AI. So we're going to be talking about the new questions that have been raised by generative AI and copyright, Korea's response. And I would like to now invite Professor Tae-hee Lee of the Korea University School of Law, who's also the acting chairperson of the Korea Copyright Commission. Let's welcome him to the stage with a big round of applause.
예, 감사합니다.
Thank you. As introduced, I am Tae-hee Lee from Korea University. All the experts from abroad and all participants, thank you for joining us today. So I will begin my presentation. The copyright regime shows the history of our response to technological advancement. Copyright was first born when printing press technology was introduced by Gutenberg. The first material that was printed by Gutenberg was the 42-line Bible. This was the first introduction of printing technology. And only the royals and aristocrats previously accessed Bible, but thanks to the printing press, it was distributed among all general public. The printing press allowed massive reproduction of books. So, privileges were granted to publishers. In 1709, Statute of Anne, the first copyright law was enacted, which was globally spread afterwards, and copyright has now really been established as a solid regime and system. Technologies have enabled people to enjoy advancements, but there was also the risk of killing human creativity. In order to counter such risk, humanity used copyright regime to respond to technological advancement. Along with printing press, camera, and radio and recording technologies, broadcasting technologies, and VCRs have all been managed under the copyright regime. Also, 3 decades ago, Internet emerged, becoming the biggest threat to copyright, only second to the printing press. In 1990s, the WIPO Copyright Treaty and the WPPT various Korean laws have been put in place to respond to the emergence of internet. But today, AI is raising many challenges. While technological benefits are reaped by humanity, on the other hand, it also threatens creativity of humanity. As copyright regime has been doing so until now, I believe that human communities will be able to find countermeasures in face of AI. Data collection, data pre-processing, AI training, and fine-tuning are various processes involved in the AI supply chain. Also, AI models trained with data are distributed in forms of API in offices to provide services so that the end user can create AI generated outputs. Developers, suppliers, service users are some of the various stakeholders in the supply chain where copyrighted works are also used and specific images and data are used. The data used for AI training or storage includes text, data, images, so in a multimodal format. This is where AI copyright issues emerge. First, there's the issue of training data. Text and data mining exception, fair use, and compensation for data used for training, and royalty payment, statutory license, and compensation to the right holders, the method of use, the reservation of rights, the adequate level of compensation or royalty, and the party who receives or collects the royalty are many of the issues. If used for non-commercial purposes or non-expressive purposes, the use of data becomes especially important. Whether a case falls under that category is becoming even more ambiguous, though. So we shouldn't be limited to TDM or fair use, but we should look at how the use of AI is impacting and what values are being created to the industries. If permission is required, then is the CMO scheme enough, or do we need an extended collective management called ECL required? Many stakeholders, including CMOs, have different preferences or opinions, which is making resolution of such issues even more challenging. Therefore, in 2023, EU AI Act was legislated, which provides many implications. The EU AI Act provides an exemption to the DSM Copyright Directive, where the AI suppliers are required to respect the reservation of rights expressed by right holders. While use of training data is allowed by AI, if the permission is not acquired from the right holder, then the use would be prohibited. So the reservation of rights is the form of limitation that enables right holders to exercise their rights. Next, there is the issue of disclosing AI training data. Transparency should be secured so that all data used for training of an AI model should be disclosed. ChatGPT 3 or 4 or Llama of Meta or Stable Diffusion are disclosing their AI training data, which shows that it is difficult for individual right holders to identify if their works is used for training. Therefore, the content used for AI training should be disclosed in a sufficiently detailed document and be made public. But how much of a disclosure would suffice the requirement? This may seem a bit vague. And to this issue, the recital says that it should be generally comprehensive in its scope, instead of technically detailed, to facilitate parties with legitimate interests, including copyright holders, to exercise and enforce their rights. When disclosing training data, trade secrets should be protected. Therefore, the database or data file list used for training should be disclosed, and the source of data should be provided in a narrative format. So this was established in February. So the method for such disclosure is yet to be publicized. Korea and other major countries may follow in terms of legislating such disclosure requirements. Another issue is AI labeling. Regarding AI outputs, labeling them as generated by AI is becoming an important issue. So any images, audios, or video content generated by deepfake, the service providers should let the public know that it has been generated by AI, and all suppliers who provide content for public interest should disclose the fact that it has been artificially generated. So generative AI providers are required to label the outputs. A working level guide has been produced in China saying that providers should assign labels for photos, videos, and other generated content. And there is a bill in Korea also pending to require such label, and there has been such amendments proposed in European countries also. Labeling encompasses some very difficult issues to resolve. So how will we regulate the AI output labeling? When we take pictures with smartphones, they use AI technology. Then, if we upload those photos taken by smartphone on social, do we have to label them as produced by AI? That might seem unnecessary. So it is important to come up with an appropriate scope and decide whether to allow exceptions, whether to only mandate certain sectors to label AI outputs. Labeling AI without giving any incentives may not be as feasible or viable, so that should be deliberated. We should look back on when DRM was mandated. Any audio-video content constituting deepfake and publishing content for public interest were subjected to such requirements in a negative method, and requirements were mitigated, and this is becoming a good reference case. Also, Facebook, Instagram, TikTok are some social platforms where attempts are made to label AI outputs. Adobe Stability AI are using content credentials, which is a part of an industry initiative to label AI outputs voluntarily. Such voluntary initiatives of the industries exist, so how to take the legal approach is a topic to be explored. So the party of labeling, the method and content of labeling, and the prevention of techniques to neutralize the labeling, and the labeling technology, and whether to enforce labeling should also be deliberated. Also, it is important to discover the content that has not labeled in order to enforce such a requirement, but whether that would be feasible in today's environment is another issue we face. The next issue is protection of AI output. Disclosure of training data are some of the more prioritized issues, so this may seem secondary, but it is a foundational question that we must look at. Should AI outputs be protected under copyright? This regime has been in fact founded on the anthropocentric concept of authors, which has its origin in the romantic authorship concept. A lonely genius author and the author's originality are elements of romantic authorship, which views authors as people who create something from nothing. It is the foundational and essential idea of today's copyright regime. Then, in today's GENAI era, is such an anthropocentric concept of authors sustainable? Well, we could take an analogy of the photographic works. Photographic works are protected worldwide under the copyright regime. In order to be protected, it must meet the requirements of creativity. Then from a creativity standpoint, the act of clicking the camera shutter and the act of putting in prompt to AI must have some differences. But what are the differences? On top of human creativity, there is the element of chance, which contributes to creativity. And also, there can be an analogy made with works made for hire. Not only employees, the actual agent of creation are human beings. So the agent of creation could be different for works made for hire and AI, but as the corporation or the employer, the legal entity becomes the creator when it comes to works made for hire, can AI also be recognized as creator? And also, there's the issue of whether AI is really autonomous. Under the current regime, can we prevent attempts to protect AI outputs as works generated by human beings? When we entrust works to a CMO, there are no practical evaluation made on those works, which is not feasible. In February 2023, U.S. Copyright Office ruled that the Zarya of the Dawn is not a human created work. If the user did not explain that they used Midjourney but just filed it as their own work, then it would have been registered because there is no way for the U.S. Copyright Office to tell the difference. If a user registers an AI-generated work as a work of their own, can a CMO or government agency really identify that as an AI output? It would be impossible. There have been numerous such cases, and I'm not saying that that is desirable. Unless we have technology to tell apart the AI-generated output, there will be multiple such attempts where human users of AI file AI-generated output as their own work. Then will it be continuously difficult to protect AI outputs under copyright. I am sure that participants here will be creating multiple photographic works with your phones as you attend today's forum. Then, among those works, how many of the works will you exercise your rights for? Then, maybe we should not simply rule out protection of AI outputs, but prove that human creator was behind the works only when there's an infringement issue, and when it cannot be proved, then remedies could be provided under the legal regime. That could be a question we can deliberate on. Next issue is striking a delicate balance between interested parties.
자, 인간이 프롬프트를 제가 좀 넘겼습니다. 자,
I skipped some of the slides, so going back. Is there human creativity contribution in AI outputs? That is another question that we face. So Zarya of the Dawn was an AI output where the user input the prompt. However, there was quite a distance between the prompt and the output. Therefore, U.S. Copyright Office ruled that the human user lacked sufficient control over the generated image to be treated as the mastermind behind the work. But if expressive elements could be designed through the prompt and parameters could determine the arrangement and the layout of the image, and the words of the prompt is used to set the parameter, after which parameters are refined and adjusted in order to arrive at the image. Such process was accounted for by the Beijing Internet Court, which ruled that the work has met the requirements of originality reflecting humans' original intellectual investment, and therefore can be protected by copyright law. The two authorities arrived at very different conclusions, contradictory conclusions. Then, this raises a fundamental question. Are AI really autonomous in the true sense? If they are, then do the works reflect human creativity? If we forecast the AI technology to continuously improve, it is doubtful that strictly current regimes can be sustainable going into the future. Also, moving on to the issue of the delicate balance between interested parties, in the early 2000s, sharing of MP3 files had an impact on the demand for MP3 files, which was a very controversial issue. But the era of MP3 files have ended, and it has been replaced with a culture of streaming, but there was a lot of pain amidst the transition. Were the right holders or creators harmed due to such evolution? If so, to what extent? And are those impacts temporary, or will it lead to an eventual destruction of human creativity? It seems that creators believe they are threatened by AI. SASEM and JIMA have made joint research based on survey, which showed that 71% of the creators believe using AI for music will threaten the livelihood of music creators, and it can be assumed that by 2028, 27% of music creators' revenues will be at risk due to GenAI. It means that for 2028 alone, the estimated potential damage will be 950 million euros, resulting in a cumulative total damage for the period of 2023 to 2028 of around 2.7 billion euros. According to a survey by US Authors Guild, 69% of authors believe their careers are threatened by Gen AI, and 70% of them believe that publishers will begin using AI instead of human authors to publish books. The Internet Property Office of UK said that the TDM exemption should be expanded, but the UK Parliament put a halt to it. They created a report on the impact of AI on creators and recommended that the proposal to expand TDM expansion for commercial uses be rolled back. So the creation cycle and the cultural advancement will be undermined, and free rider problem could be arised, which were taken into account to arrive at that decision. The WGA strike and the strike of the actors really showed how much of a fear they have of being replaced by AI. So some policy decisions should be made. These cases of strikes around the world show many implications of the impact of AI on the creative industry. There is the EU AI Act provision which allows the reservation of rights to be expressed by rights holders. This is the opt-out provision. So the AI supplier is obligated to respect copyright, and the reservation of rights should be identified by rule. This gives a solid position for rights holder and is reasonable that they are given the option to opt out from the TDM exemption. So the legal decisions or legislations regarding training data for AI will be necessary, but until then, this opt-out provision will function as a norm. But robot TXT are also some measures being used, which requires developers to acquire permission from the rights holders, but that whole process should be facilitated. There was the basic agreement reached between WGA and AMPTP. They did not completely rule out AI or completely allow indiscriminate use of AI. They arrived at a compromise which allowed the interests of all parties to be secured. So both the employer and the labor side allowed the use of AI, but added safeguards. Although the AI-produced material could be used as basic reference material, that fact should be disclosed, and the use of such AI material should not be used to determine the writer's compensation. Printing press has been invented more than 6 centuries ago, and the privileges granted for publishers were first introduced in 1469. And the first copyright legislation was made in 1709. And now we face this new technology, artificial intelligence. Will copyright regime manage to overcome issues due to AI? No one knows the answer, but I have confidence it will, as long as we strike the right balance among all stakeholders. In Korea, MCST and Korea Copyright Commission are making a lot of effort to resolve AI issues. In 2023, the AI copyright law working group has been launched. Through such working group, dozens of meetings were held to arrive at the guide on generative AI and copyright. It was published in both Korean and English in December 2023. I believe Korea is the first in the world to produce such a guide for GENAI and copyright issues. February this year, the second round of the AI copyright law working group was launched. It deliberates many issues. As I've briefly mentioned, the lawful use of training data for AI models, the copyright limitation for AI training data, comprehensive measures, the collection of feedback from right holders and users, and infringement issues, AI output labeling, registration of AI output, and the legal nature of prompt input, and the proof of human creativity contribution in AI outputs are some of the various issues that will be included in the report that will be published the end of this year. A lot of discussion, compromise legislation will be necessary, so many of these issues will not be solved overnight. Nonetheless, Korea's MCST and KCC continue to make efforts to resolve the emerging issues relevant to copyright and AI, and will continue to do so. I believe that today's forum is one of the many attempts pulled together by MCST and KCC to solve the many issues that we face. I hope that we will make one step closer to the resolution of these issues through today's forum. Thank you.
네, 좋은 발표.
Thank you very much for your insightful keynote speech, Professor Lee. This book talked about the development of technology and the changes of copyright regime. When it made the AI, a new environment has been forged, and he has also talked about some of the challenges that we face against this kind of backdrop. The AI and copyright law working group was formed in Korea, and for the first time, a guide on AI and copyright was published, and this year, the second round of the working group meetings will be implemented. So we believe, and you can see that the Korean government and the Korean counterparts are really proactively responding to AI. So we're going to have a short break, and at 11 a.m. we are going to start off with session number 1. If you have any questions, please use the QR code on the screen in front of you, and you'll be able to ask some questions. We will collect the questions and deliver them to the moderator. So see you in 15 minutes.
네, 2024 서울 저작권 포럼 첫
We will now begin the first session of the Seoul Copyright Forum 2024. We will be exploring the government initiatives of major countries, EU, the US, and Japan, with regards to the policy responses to GenAI from the government policymaking and academia perspectives. Our first speaker is attorney advisor, Mr. Darren Pogoda of USPTO, who is in charge of advising for copyright law and policy. Please welcome him to the podium with a big round of applause.
Good morning, everybody. First, just let me please extend a sincere thank you to my friends in the Korean government, particularly Mr. Lee from the Commission and Ms. Ha-Yoon Choi from the Copyright Bureau for the honor of inviting me to speak here at the Seoul Copyright Forum and for the very warm welcome and accommodations they've provided me. It's a pleasure to be here and a wonderful opportunity for me to learn from some of the other distinguished speakers. So I will be discussing the U.S. experience, to date anyway, with generative AI and copyright, and about how my government is currently studying and addressing many of the important and complex legal and policy questions posed by the intersection of copyright law and AI. In short, I can tell you that it is no easy task. It is keeping a lot of people quite busy. But I can say that the United States' fundamental goal when it comes to governing AI is to make sure we leverage its many benefits while mitigating the risks of potential harm. I will open today by talking about the role of my agency, the U.S. Patent and Trademark Office, within the larger federal government AI policy-making apparatus, and then discuss some of our efforts and activities as they relate to copyright and AI. And then I will follow that up with a discussion about the roles and efforts of other agencies and actors within the United States government, including the Federal Trade Commission, the United States Copyright Office, Congress, and last but not least, the judicial branch, where there is much pending litigation. That is a lot of ground to cover in a short amount of time, so let's get started. Let me start by describing the role of my agency, the U.S. Patent and Trademark Office. Just briefly, we are part of the Department of Commerce and part of the executive branch of the United States government. We have many duties, but we have a statutory duty to advise the president and other executive branch agencies on domestic and international IP issues, including copyright. And the office within the USPTO that assists in this advisory role is my office, the Office of Policy and International Affairs. And given that the focus of today's events is copyright, I should also note that when my agency is exercising these duties, that the director of the PTO is required to consult with the Register of Copyrights on all copyright-related matters. And so historically, we have a very close, a very cooperative, a very friendly working relationship with the U.S. Copyright Office. And indeed, the current Register of Copyrights, Ms. Shara Perlmutter, actually used to be the head of my office at USPTO before she assumed her current role. Generative AI has been the buzzword since at least November 2022, for anyone that can remember back that far. That is when ChatGPT was first publicly released to the world by a company called OpenAI. The powers of this tool are rather astonishing. Users can prompt ChatGPT to write a short story, let's say, in the style of Hemingway or just about any other famous writer, and coherent results will appear in seconds. It can be used in up to 95 separate languages, and just one item that just sort of, there's new items about its powers every day, but just one item that kind of grabbed my attention as a lawyer was that the latest version of ChatGPT, ChatGPT-4, passed the uniform bar exam by a significant margin. For those that don't know, the uniform bar exam is a test that most American lawyers have to take in one form or another before they actually work as an attorney after completing law school. So one day there could be, I hope not, but there might be an AI chatbot from the United States that you're inviting to come speak here, which would be a shame because I really like my job. while AI appears to be the next hot topic that everyone wants to talk about, I can say with a little pride that my agency has actually been working on the issue for years. And that work started way back in 2019 when we hosted a one-day public event on AI and IP considerations. Later that same year, we requested public comments on the impact of AI on certain IP policy areas, including copyright, but also patents, trademarks, database protections, and even trade secret law. In 2020, after gathering those comments, we issued a 50-page report summarizing the views of stakeholders on AI and IP. That 2020 report, I think it's still useful to consult, even though it obviously predated the emergence of the generative AI models that we're talking about today. But it took a comprehensive look at a wide variety of stakeholder views on the impact of AI as that landscape was just beginning to take shape. And so it provides a nice historical record, if you will, as to what people were thinking when all of this started off. And then my agency, in turn, was able to use that work as a springboard to focus on issues for continued exploration and public engagement. And then finally, in 2021, we hosted a public event in consultation with our friends at the Copyright Office on copyright law and AI, where we did a number of things, but one of the things we tried to do was we tried to guess what the future of AI and copyright might look like. So for those with a desire to go back in time, there is a video of this event available on our website, and you can see how we did. And so to sort of build on this initial work that we did early on and to encourage innovation in AI while also, importantly, promoting reliable and predictable IP rights regimes for this technology, my agency formed a group called the Artificial Intelligence and Emerging Technologies Partnership. The partnership is an ongoing cooperative effort between the PTO and the AI community to explore various issues, and selfishly as an agency to help us better understand the public's views so that we can help inform our work going forward in this space. And that partnership has already held a series of meetings over the past couple of years. One item I would point out to you occurred recently in March of 2024. It was a public symposium. We hosted in partnership with our friends at Loyola Law School in California. It explored a number of issues relating to AI and copyright, including a lot of the ongoing copyright litigation in the United States. We'll talk about that more later, but also a discussion of name, image, and likeness issues. There's a video of this event available on our website. I would recommend it to anyone interested in these issues. I found it quite informative. Like many countries, though, like many jurisdictions, our engagement on AI issues has increased exponentially over the past year and a half. One of the more prominent items amongst this work occurred in October of 2023, when the Biden administration issued a comprehensive executive order on the safe, secure, and trustworthy development and use of artificial intelligence. That's the name of the order. It's 37 pages long. It can take a while to read through, but if you like, there's a handy summary of its contents that could be found in a fact sheet published by the White House, easily accessible on its website. Just turning to some of the IP issues, that order tasked the PTO with certain deliverables, including a section that requires us to consult with the Copyright Office and issue recommendations to the President on potential executive actions relating to copyright in AI. The order states that those recommendations should address Any issues discussed in the Copyright Office's studies, including the scope of protection for works generated by AI and the treatment of copyrighted works used in training. In terms of a timeline, we are required to issue these recommendations within 180 days after the Copyright Office publishes its own AI studies. And we'll talk more about the Copyright Office's work later on in my remarks so you can see how these pieces kind of fit together. Another agency addressing AI and copyright in the United States is the Federal Trade Commission. For those unaware, this is an independent agency that focuses mainly on competition and consumer protection issues. They issued their own report in late 2023 that discussed how the generative capabilities of AI is affecting professionals in the creative field. The report noted the concerns of creative professionals, including that their works are being used to train AI models, and the impact that these models are already having on their industries and livelihood. It noted that it will continue to closely monitor these developments and will remain vigilant about using its powers to foster fair competition and to protect consumers. It also highlighted areas of potential study, including the potential for the study on the potential for the impact of opt-out regimes. Turning now to some matters outside the executive branch, the U.S. Copyright Office is actually part of the Library of Congress, which is part of the legislative branch. And in early 2023, the Copyright Office launched its own initiative to study copyright and AI. That work initially included a series of public listening sessions and webinars, and also a statement of policy on the registration of AI-generated works. That statement was issued in March 2023. It's available on its website. It said a lot, but essentially it reaffirmed the requirement of human authorship, and it instructed applicants that they needed to disclaim any AI-generated content in their work that was more than de minimis. A little more prominently, the Copyright Office also issued a public notice in August of last year requesting public feedback on a broad range of AI and copyright questions. That call for comments actually contained 34 separate questions. That number is a little misleading because many of those 34 questions had multiple subparts to them, so it's actually quite dense. The questions covered a number of topics relating to ingestion, transparency, labeling and record-keeping requirements, copyrightability questions, licensing issues, and the treatment of digital replicas and likenesses. In response to that call for comments, the Copyright Office received over 10,000 separate comments. That included both initial and reply comments. I thought that was quite a bit until I read a few months back that our friends in Japan had a similar public consultation through the Council for Cultural Affairs, an agency there, on AI and copyright. And they actually received over 25,000 comments in response to their call for comments. So I issue both my congratulations and condolences to my friends in Japan that had to fight through all of those comments. You might be wondering what is going to be done with those 10,000 comments. And so I can tell you that the Copyright Office, this is nothing they haven't stated publicly, by the way, plans to issue a report in several different sections over the course of the fiscal year, which for us ends on September 30th, that will summarize its findings, make some conclusions, and make recommendations about potential legislative and regulatory action. The first section of that will focus on digital replicas. The second section will address the copyrightability of works that incorporate AI, and that is due to be published later this summer. And finally, later sections will focus on the topic of training AI models, as well as licensing considerations and liability issues. The goal, again, is to finalize all sections of this report by the end of the fiscal year. Additionally, if there are any economists in the room, you might be interested to know that the Office of the Chief Economist, a relatively new office within the U.S. Copyright Office, is busy working on a report that they have stated will come out later this year that will provide a careful examination of some of the various economic issues surrounding AI and its potential effects on the larger copyright ecosystem. It will also contain some guidance on what research might be most impactful going forward in terms of policy decisions. Turning now to some other parts of the government, the United States Congress has also been busy. They've held at least 6 hearings over the past 18 months directly addressing the implications of AI. Those hearings have covered a lot of ground with a lot of testimony and a lot of questions. But just to summarize as best I can at a very high level, those hearings generally revealed some pretty sharp disagreements among the copyright stakeholders. Copyright owners generally welcome AI as a new tool to enhance their work, but argue that the AI systems should not use their works without consent, credit, and compensation. AI companies and related stakeholders, by contrast, have argued that the ingestion of copyrighted works to train their models should generally be protected by fair use, and so that therefore no consent, credit, or compensation is required. Congress, like the executive branch, has also formed some working groups to tackle these issues. I think most prominent of these occurred in the U.S. Senate, where the Senate Majority Leader, Mr. Charles Schumer, created and led what is known as the AI Insight Forum on Copyright. It was launched in 2023. They've been quite busy over the past year and a half, but the forum was designed to bring together key leaders in the AI field to discuss some of the risks and opportunities posed by AI, and most importantly, how Congress could go about best crafting and drafting legislation to best address them and find opportunities that balance both innovation and safety. That forum held 9 separate closed-door listening sessions, and if recent news reports in the days before I left to come out here are true, it is quite possible that there could be some actual legislative proposals emerging from their work very soon. So just turning now to some actual legislation, I'm going to focus primarily on one issue, and I will concede that the United States probably hasn't been as active as some other jurisdictions in terms of enacting actual legislation. But I think it's fair to say that the issue receiving the most attention from our Congress so far is how best to deal with AI-generated works that imitate the voice or likeness of another person. And so just by way of background, in the United States, this is generally not a matter of federal law or even a matter of copyright law for that matter, but it's mostly a creature of individual state law. And those laws vary from state to state. Some have it in statutes like California, some have it in their common law or case law, some have none at all. Sometimes you'll hear this referred to as a right of publicity right, and that can just generally broadly be defined as the right to prevent unauthorized commercial uses of one's name, image, voice, likeness, some core aspect of a person's identity or persona. It also intersects a little bit with trademark law, with the Lanham Act, which is the trademark law of the United States. And so my agency has been taking a bit more of a leading type role with this issue, given the intersection between copyright and trademark. And so I think that recent uses of AI to create some amazingly realistic deep fakes, replicas, simulations of real people or their voices have prompted a lot of members of Congress to call for the first time, federal legislation to protect these types of rights. And no actual legislation has been introduced yet, but there is a discussion draft, which was actual legislation, but it was just a discussion draft put out for sort of people to digest. It was released by several senators in October of last year, and it would provide for the first time a federal property right for voice and visual likenesses of all individuals against the unauthorized recreations by generative AI. And so we are already actually starting to see in the United States some actual cases, some actual litigation where name, image, and likeness rights are intersecting with copyright-based rights. I'll give you one example. It was a lawsuit filed in January of this year by the estate of a famous, now deceased comedian named George Carlin. Maybe some of you are familiar with him. His estate filed a lawsuit against the defendants, and the lawsuit was based on what they alleged was an unauthorized comedy program that they alleged was delivered by an AI-generated imitation of George Carlin's voice. And that complaint contained a couple different counts. So the first count was copyright-based, and it said that it alleged that the defendants infringed the copyrights by making copies of George Carlin, the famous comedian's work, to train their AI model. So that was the copyright claim. And then it also said that the plaintiffs also said that the defendants violated Mr. Carlin's right of publicity claim under California law by using Mr. Carlin's name, image, or likeness to promote their unauthorized copyright claims. That's a lot for a court to work through. The case recently settled, actually, so the court won't be forced to address those issues anytime soon, but I don't think it'll be the last time we see that type of case cropping up. And I think what was also getting Congress's attention on this is the fact that these name, image, and likeness rights were coming up in other contexts as well outside the court. Just one example, this potential for AI to imitate one's voice and likeness was actually a key contested point of contention in recent negotiations for a collective bargaining agreement between members of the Screen Actors Guild. This is a union that represents movie, television, radio actors, and the television and movie production studios, including streaming services. And so in those negotiations, the union members were concerned that AI was going to be used to alter or replace the actors' performances without their permission, of course. And so after some hard-fought negotiations, the final agreement between the union members and the production studios, which was finalized in December of last year, actually now requires the studios to obtain consent from the actors before they create or use a digital replica of an actor. There's a few other pending pieces of litigation too. I'll discuss one here just to give you a kind of an idea of what some members of Congress are thinking. This was the Generative AI Disclosure Act of 2024. It was introduced in April of this year. It hasn't gone very far other than being introduced, but it would require creators of AI training data sets to submit a notice to the Copyright Office identifying any copyrighted works that were used in building their generative AI systems. This legislation would only mandate disclosure, mind you. It would not mandate any payment of remuneration or royalties. But I think one could easily see how a law could help facilitate litigation by letting right holders know that their works have in fact been ingested by an AI system, which we'll discuss in a little bit is not always an easy thing to uncover. So, litigation. Finally, as you might expect, AI has generated a flurry of litigation in a country that loves litigation. These issues, these generative AI issues, raise a number of complex questions relating to copyright law and policy, relating to input, to output, and finally, of course, questions about who can or should be liable. We'll start with the outputs litigation first, because there has been less of it, so it's just a little easier to deal with. But with respect to generative AI outputs, the major case is the Thaler case. And in this case, Mr. Stephen Thaler attempted to register with the U.S. Copyright Office a piece of visual artwork, you can see it here, that he conceded, he disclosed to the office was autonomously authored by an AI program that he called the Creative Machine. The Copyright Office issued a refusal, and Mr. Thaler, by right, appealed that administrative refusal to the local federal district court in Washington, D.C. In August of last year, the federal district court affirmed the Copyright Office's refusal to register the work, based primarily on the fact that human authorship is an essential part of a valid copyright claim. There was none here, so this one, on its facts, seemed a little easy to deal with. Mr. Thaler, however, doesn't appear ready to give up the fight. He appealed that decision from the federal district court in October of last year. That case has been fully briefed. I don't believe oral argument has been set, but it probably will be soon. And so we'll be getting another ruling on this issue from the D.C. Court of Appeals in due course. And this is a case that a lot of lawyers in America are keeping a close eye on. On the input side, things have been a little busier and a little messier. On the input side, copyright owners have filed, it's actually about 30 lawsuits. This will just give you an idea as to how quick things are moving. When I needed to submit my materials in advance to the organizers of this conference to prep them for you and translate them and everything, there was about 25, but there's been more since then, so it should say 30. And those lawsuits have alleged that the use of their works to train AI systems constitutes copyright infringement. It'd be impossible to discuss each case in detail, but I'll try and give you the best overview I can of all the cases writ large. 20 cases were filed as class action lawsuits, and 10 were lawsuits of the traditional party versus party variety. Class action lawsuit, I realize that's somewhat unique to American jurisprudence, so for those unfamiliar, very quickly, this is a lawsuit where the named plaintiffs represent not only themselves, but also potentially, with permission from the court, and there's a whole process for that, potentially a much larger group of persons who are alleged to have suffered the same harm based on the defendant's same alleged misconduct, in this case copyright infringement, but it could be any tort. So that total number of 30 is not a static figure. It actually represents the number of lawsuits that have been filed, not necessarily the number that are currently pending. There's some of the class action lawsuits have been consolidated together, and a couple have actually settled. So the majority of the lawsuits have been filed in federal courts in combination of California and New York. No surprise there. There is actually one very important case actually pending in Tennessee and another in Delaware. The plaintiffs in these cases represent a broad cross-section of the creative ecosystem, and they include book authors, visual artists, journalists, photographers, newspapers, voice actors, musicians, you name it. Nearly all of the lawsuits involve claims of actual direct copyright infringement. Others involve claims of secondary copyright infringement, and others still involve claims relating to the misuse of copyright management information, meaning liability based on the removal or alteration of copyright management information. And others still involve some combination of all these claims. And I think my time is up. I just need about a minute to wrap up. I wish I had some firm answers for you. All of these lawsuits remain pending, however. To date, no U.S. court has issued a ruling on whether the ingestion of copyrighted works by AI systems constitutes copyright infringement. So I'm sorry if you were coming here looking for that answer. I don't have it for you yet. But I do think that these cases, however, will shed more light on how AI claims are being litigated, a story unto itself that is quite interesting, and how fair use might, can, or should apply within this context. Let me close with just a couple notes. Before any courts give us those answers on fair use, I think it's worth noting that there are a couple of very important underlying questions that maybe people aren't paying as close attention to with respect to this litigation. So, for instance, one would be, how can copyright owners even discover that their works have in fact been ingested by an AI developer? Are the AI companies retaining the type of data that plaintiffs might need to prove this type of ingestion? These questions are relevant not only to a particular court deciding a case, but also I think they speak directly to the international issues of AI and why a lot of people like us are gathered in a room today. It's quite possible, for instance, that the disclosure requirements in the EU's recent AI Act could provide copyright owners with a tool to find out for certain if their works have been copied, and then they can and could in turn use that information to file lawsuits in or outside of the EU. And then an even more fundamental one, and I'll finish up after this, is before we even get to possible defenses for copyright infringement, like fair use, plaintiffs will need to prove, infringement, likely of the reproduction right. Can the plaintiffs in these cases prove that at some point in the ingestion process, copies of their works have actually been made, and for more than a transitory duration? For anyone that's studied this, at least to me anyway, the ingestion process is opaque, murky, a little mysterious, highly technical. So I don't think the infringement aspect of this can or should just be assumed. It will need to be proven. To date, some plaintiffs in the U.S. appear to be relying on circumstantial evidence to do this by pointing to infringing outputs of generative AI systems that produce nearly identical works to the copyrighted works at issue, and essentially saying to the court, hey, look, there's no way this AI model could have produced this identical work unless my client's copyrighted work existed there in their system at some point, past or present. I'll just close by saying that the technology is difficult to understand. These are not easy questions. I'm happy to say that the courts in America are grappling with them. I would just humbly note that I think it's important to pay just as close to these sort of stepping stone type issues in this litigation that might not be getting as much as attention as fair use, because they are just as important, just as nuanced, just as complex. I don't know how these cases will be resolved. It would not be wise for me to guess, but I do think that we are all going to learn a lot more about the underlying technology of AI and how it works, and hopefully a lot more about copyright law as these cases get deeper into discovery. So I told you there was a lot to get to. My remarks just scratched the surface, but I do hope that I gave you a good, efficient overview of some of what the United States has been up to. And I look forward to listening to and learning from the other speakers in the room. Thank you very much for your time.
네, 대런 포고다 법
Attorney Advisor Darren Pogoda, thank you for your presentation. The U.S. initiatives regarding copyright and GENAI were covered starting from the administrative order and the Council and their activities regarding copyright and AI were covered, and I am looking forward to hearing more about updates on the lawsuits. Our next speaker is from Japan's Agency for Cultural Affairs. Starting from 2022, he has been researching GENAI and copyright, and starting from 2023, he is in charge of the Copyright Act amendment. So we have Senior Attorney Advisor Yukihiro Miwa. Please welcome him with a big round of applause.
I am Yukihiro Miwa, and I am an attorney advisor at the Japan Copyright Office under the Agency for Cultural Affairs in Japan. I am honored to speak at the Seoul Copyright Forum 2024 today. Our focus today is on the intersection of generative AI and copyright in Japan. This is an area of increasing importance and complexity as AI continues to evolve and its applications become more widespread. Let's begin with the overview of the government study on AI and copyright in Japan. In May 2023, during the G7 Hiroshima Summit, the Hiroshima AI process was launched. This process aims to establish an international framework for AI governance, which includes considerations from an intellectual property perspective. In June 2023, in the Strategic Program on Intellectual Property 2023, the government directed us, the Copyright Office, to clarify the relationship between AI and copyright. One of the main reasons for the Japanese government initiative to clarify the relationship between AI and copyright is the growing concerns and uncertainty about how to interpret the relationship between AI and copyright, led by the rapid development and widespread use of AI. There has been a strong demand to address these concerns promptly. In response to these concerns, the Japan Copyright Office decided to conduct a study on the relationship between AI and copyright within the Cultural Council. The Council commenced its study on generative AI and copyright from July 2023 to March 2024. For this study, the Council gathered opinions from a wide range of stakeholders, including AI-related businesses, AI users, creators using AI and not using AI, and other right holders whose works are used for AI training. Finally, in March 2024, the General Understanding on AI and Copyright in Japan was officially published, encapsulating the insights and conclusions of our studies and public feedback. Now, let's move on to the main topics we will cover today regarding AI and copyright. We will discuss the basic concepts on AI and copyright and provide an overview of the general understanding. The overview is divided into three parts: the AI development and training stage, the generation and utilization stage, and the copyrightability of AI-generated materials. Finally, we will look at the outlook for the future. These topics will provide a comprehensive understanding of the current state and future prospects of AI and copyright in Japan. We will explore the implications and the legal frameworks governing these areas. Let's start with the basic concepts on AI and copyright. The Japanese Copyright Act aims to strike a balance between protecting the rights and interests of copyright holders and ensuring the smooth exploitation of copyrighted work. This balance is also crucial when considering matters related to AI business. The rapid development and widespread use of generative AI have raised concerns about the lack of clarity regarding the relationship between AI and copyright. Normally, the provisions of the Copyright Act should be interpreted by the judiciary on a case-by-case basis. However, there are currently very few precedents that directly address the relationship between AI and copyright. In response to these concerns, a council composed of experts was convened to discuss how the current Copyright Act should be applied in relation to AI. To provide precise views on AI and copyright, the Council has differentiated between the AI development and training stage and the generation and utilization stage. During the AI development and training stage, creating a training dataset by collecting and reproducing copyrighted works is a significant focus. This stage involves developing AI by using these datasets for training. In the generation and utilization stage, the focus shifts to generating materials using AI and making them public, such as uploading AI-generated materials or selling copies of these materials. It is also crucial to consider whether AI-generated materials are eligible for copyright protection and can be classified as copyrighted works. The Council has discussed the relationship between AI and copyright with a focus on the concerns of various stakeholders. The main topics covered during the discussion are, as you can see in this slide. These discussions aim to provide a comprehensive understanding of how the current Copyright Act should be applied in relation to AI, and to address the legal concerns of stakeholders in this rapidly evolving field. In March 2024, the General Understanding on AI and Copyright in Japan was compiled based on the Council's examinations. This document represents the Council's views on the interpretation of the current Japanese Copyright Act as it applies to AI. The general understanding aims to help concerned parties understand the presence and extent of legal risks associated with the use of copyrighted works in relation to generative AI. By fostering this understanding, it enables stakeholders to proactively address these risks. Additionally, it supports the protection of copyright and neighboring rights for rights holders. It is hoped that this document will serve as some sort of guideline on the relationship between AI and copyright to help addressing concerns of the people involved about legal uncertainty and ambiguity regarding AI and copyright. To disseminate this understanding and inform the public, the Copyright Office has created and published an overview of the general understanding on its website in both Japanese and English. Now, let's take a closer look at the overview of the general understanding, starting with the AI development and training stage. Article 30-4 of the Copyright Act is particularly relevant here. This article allows for the exploitation of copyrighted works for non-enjoyment purpose, such as AI development or other forms of data analysis, without requiring the permission of the copyright holder. This includes the reproduction of copyrighted works to create a training dataset for AI. The theoretical background for Article 30-4 considers the financial benefits to copyright holders as reward for fulfilling the intellectual and emotional needs of users. In contrast, the use of works for non-enjoyment purposes is generally seen as not harming the financial interests of the copyright holder, and thus does not require their permission. This copyright exception was introduced in 2018 by reference to fair use doctrine and adjusting it to fit Japanese custom and legal culture. Continuing with the overview of the general understanding, we further examine Article 30-4 of the Copyright Act. The provisions of Article 30-4 do not apply if there is the enjoyment purpose of the exploitation. even if the non-enjoyment purpose coexist. Where a work is used for non-commercial or research purposes, if there is also a purpose of enjoyment, permission from the copyright holder is required. Article 30-4 does not apply when the exploitation of work unreasonably prejudices the interests of the copyright owner. This is the Article 30-4 proviso. This includes reproducing a copyrighted database work designed for data analysis and available for a fee without compensation, because such a database is licensed in the marketplace for data analysis purposes. Applying the provisions of Article 30-4 to these cases would unfairly impact the financial interests of the copyright holder, who gains economic benefits from licensing these datasets. Therefore, Article 30-4 does not apply to such case because the proviso. Here is the text of Article 30-4 of the Copyright Act. Now, let's discuss cases where the non-enjoyment purpose requirement is not met. When copyrighted works are reproduced for AI training, but also serve an enjoyment purpose, Article 30-4 does not apply. For instance, reproducing a copyrighted work as AI training data with the aim of generating materials similar to that existing copyrighted work is considered to have the purpose of enjoyment. This can occur in cases such as fine-tuning on the foundation model where intentional overfitting is performed. Furthermore, when it comes to the utilization of already developed generative AI, particularly the use of copyrighted works as input data to instruct the AI to generate new content such as for some kind of the retrieval augmented generation, the non-enjoyment purpose requirement may not be met. Using copyrighted works in this manner to output the creative expression of those works fails to meet the non-enjoyment purpose requirement. With the spread of generative AI, it has become possible to create materials that imitate the style of specific creators. This has raised significant concerns among creators about impersonation by third parties and the risks of losing their jobs due to other freeloading on their distinctive styles. As a result, there have been strong voices of concerns from creators about the imitation of their styles. In response to these concerns, the general understanding addresses the issues of imitating styles. Copyright protection under the Copyright Act extends to the creative expressions of ideas, not the ideas themselves. However, as is well known, the distinction between ideas and creative expressions is not always clear and determined on a case-by-case basis depending on the specific circumstances. The general understanding highlights that fine-tuning using a group of works consisting solely of a specific creator's copyrighted works can be seen as including the purpose of enjoyment. Therefore, Article 30-4 may not apply in such cases. This is because such a fine-tuning can often be seen as imitating not only the ideas but also the creative expressions, even if the developer of this AI insists that they aimed to imitate the creator's style as an idea. Next, let's discuss the proviso of Article 30-4, which addresses cases where the exploitation of works may unreasonably prejudice the interests of the copyright owners. As mentioned earlier, the proviso applies if the reproduction of a copyrighted database work, which is designed for data analysis and available for a fee, occurs without compensation. For example, consider a news website on the internet If a database consists of news articles of this news website, which is designed for data analysis, is available for a fee. To collect article data from this website for AI training can fall under the proviso of Article 30-4. Even if a database is not licensed for a fee yet, when this website implements measures to prevent data collection for AI training, such as access restrictions through IDs and passwords, or blocking crawlers with a robots.txt file, the news articles on this website may be intended for future sale or as a database for data analysis, including AI training. In case like this, the situation is similar to when copyrighted database for data analysis are already licensed for a fee. Therefore, to bypass these measures and collect data for AI training is considered to impede the future sales channels of the copyright holder. Thus, these reproductions of works potentially falling under the proviso of Article 30-4. Therefore, it is recommended for the AI-related businesses to respect these technical measures to prevent collection for AI training data. Next, we will discuss the issues of reproducing infringing copies for AI training. There are still many pirated content available on the internet. In cooperation with right holders, Copyright Office is working to crack down on piracy and eliminate pirated content from the internet. However, complete eradication has not yet been achieved. It is essential that data collection for AI training does not contribute to the spread of pirated content. According to legal precedents, a person other than the direct infringer may be held liable for copyright infringement. If an AI developer or AI service provider collects training data from a website known to distribute pirated or infringing content, there is a high possibility that the business will be held responsible for any copyright infringement caused by the generative AI developed using that data. Copyright Office is firmly committed to not allowing any actions that could promote piracy in the context of AI training data collection. It is essential for the AI-related businesses to avoid collecting AI training data from websites that distribute pirated or infringing content. Moving on to the next slide. Let's dive into the requirements for copyright infringement, specifically focusing on similarity and dependence. When AI-generated images or copies thereof are generated and used, copyright infringement is determined based on the same criteria as for traditional works. This means that if there is similarity between AI-generated material and an existing copyrighted work, and AI-generated material is dependent on this work, it will be considered an infringement unless there are applicable copyright exceptions. Similarity refers to shared creative expressions between the AI-generated materials and the existing copyrighted work. Dependence, on the other hand, means that the AI-generated work is based on or derived from the existing copyrighted work. Now, let's explore the concept of dependency in the context of AI-generated content. Based on previous judicial precedents in Japan, even when it is uncertain whether a particular copyrighted work was used in the AI training data, dependency will be presumed if the copyright holder can prove that either the AI user had access to the existing copyrighted work or the AI-generated material has a high degree of similarity with the work. This means that the copyright holder can establish dependency even if it is unknown whether the AI actually used the work during its training. In contrast, the general understanding indicates that when it is clear that an existing copyrighted work was used for AI training, it is assumed that there was dependency on a pre-existing copyrighted work, even if the AI user was unaware of the work. Next, let's discuss the countermeasures for copyright infringement involving AI-generated materials. Under Japanese Copyright Act, if copyright infringement occurs, the copyright holder has the right to seek injunctive relief against infringing party and to request the infringer to take measures to prevent further infringement in the future. Based on this, in the case of AI, the following considerations apply. If a copyright holder discovers their work has been infringed by the use of generative AI, they can seek injunctive relief against the infringing party. This injunction may include prohibiting the creation of new infringing materials, as well as the use of already created infringing materials. The copyright holder can also request the destruction of AI-generated materials that were created as a result of the infringement. In certain cases, the copyright holder may request that the infringing material be removed from the AI training dataset used for the further development of the generative AI. Additionally, the copyright holder may ask AI developers and AI service providers to take appropriate measures to prevent further copyright infringement caused by generative AI. These measures might include implementing technical limitations to prevent the AI from generating outputs based on certain inputs or inhibiting the creation of similar materials that may infringe on copyright works used for AI training. It's important to remember that the exact measures taken in response to copyright claims will be determined by a court in a case-by-case basis, considering their necessity and other relevant factors. Next, let's examine the cases in which AI-related businesses may be liable for copyright infringement. The primary responsibility for copyright infringement due to the use of generative AI typically falls on the AI users. However, there are instances where the AI-related businesses should be held accountable, such as when the generative AI itself produces numerous infringing materials due to defect. These concerns have led to discussions on the liability of AI-related businesses. Based on the current judicial precedents, not only AI users, but also businesses that develop or provide AI services can be held liable for copyright infringement related to AI-generated materials. The general understanding indicates that the factors that increase or decrease the likelihood that businesses will be held liable. For example, it is recommended for businesses to take proactive measures to prevent the generative AI from generating copyright infringing materials beforehand with the provision of that AI. Let's now move on to the copyrightability of AI-generated materials. According to the Japan Copyright Act, a copyrighted work is defined as a creatively produced expression of thoughts or sentiments that falls within the literary, academic, artistic, or musical domain. Materials that are autonomously generated by AI, meaning they are created without any human instruction or only with simple prompts like draw a cat, are not considered creatively produced expressions of thoughts or sentiments. Therefore, they do not qualify as copyrighted works. On the other hand, if AI is used as a tool by a person to creatively express their thoughts or sentiments, then the material is considered a work, and the person who used the AI is regarded as an author. Determining whether a person has used AI as a tool depends on two factors: whether the person had a creative intention and whether they made a creative contribution to the final work. Next, let's discuss the relationship between the instructions given to AI and the copyrightability of materials. The copyrightability of AI-generated materials is determined on a case-by-case basis. Specifically, it is assessed through the extent of creative contribution that surpass mere effort. The general understanding indicates some factors that constitute a creative contribution. For example, detailed instruction that specifically indicate what constitutes creative expression and repeated attempts to while checking the generated materials and correcting the instruction. Additionally, if creative expressions are added or corrections are made to AI-generated materials, those added or corrected parts may be considered copyrighted works. So far, we have reviewed the overview of the general understanding. Finally, let's look at the future outlook for AI and copyright. The general understanding discussed today is a summary of the Council's tentative consensus on AI and copyright. As I mentioned earlier, the general understanding was compiled to address the concerns and ambiguities surrounding the relationship between AI and copyright. The Copyright Office will continue to gather information on various topics for the potential revision of the general understanding if necessary. While examining these legal frameworks is crucial, it is more important to bring good practices into the relationship between AI and copyright. To ensure the implementation of good practices in the intersection of AI and copyright, it is essential to facilitate effective communications among relevant parties involved, including copyright holders, AI developers, AI service providers, and AI users. Generative AI technology is built upon the creative activities of humankind. If the sustainability of human creativity is compromised, the sustainable development of generative AI technology becomes impossible. Therefore, it is hoped that a mutually beneficial relationship fostering a fruitful content creation environment and cultural development will be established between generative AI and its associated businesses and creators. In conclusion, the general understanding provides a foundation for navigating the complexities of AI and copyright in Japan. It is essential for all stakeholders, including copyright holders, AI developers, AI service providers, and users, to engage in ongoing dialogue and collaboration. By doing so, we can foster an environment that respects intellectual property rights while encouraging innovation and creativity. Copyright Office will continue its effort to address the profound issues raised by generative AI to facilitate effective communications among the involved parties in the intersection of AI and copyright. Thank you for giving me the opportunity to speak today. I look forward to seeing our discussions advance and yield fruitful results. Once again, thank you for your attention.
네, 좋은 주제로 말씀해 주신
Thank you Attorney Advisor Yukihiro Miwa for your elucidating presentation on Japan's initiatives responding to GenAI and copyright. We could see that you have a very systematic approach, including the issues of copyrightability. We will move on to the next presentation by Professor Thomas Margoni from KU Leuven, who is researching online technology from a comparative law and EU copyright law perspective. Please welcome him to the stage with a big round of applause. Thank you.
Thank you very much. Good morning to everyone. First of all, I would like to thank you, the organizer of the Seoul Corporate Forum, the Korean Corporate Commission, and the Ministry of Tourism. It's great to be here. It's a big honor to be here with you today, together with such great speakers and with an amazing public. So thank you for that. It is good to be here, or I should say, that is good to be back in my case. I have this great privilege of being here for the second time. The first time was 2016, if my memory slightly jet-lagged works well. And when I was here in 2016, the topic of the event was text and data mining. So I thought that today would make sense in some sort of ideal completion of this circle to start with a short reminder of the text and data mining provision that since then have been implemented in the EU legal order, because as we will see, this formed the basis for training generative AI models as recently confirmed by the AI Act. So as a way of a very, very short reminder, we have a very broad definition of text and data mining, which means any automated analytical technique aimed at analyzing text and data in digital form in order to generate information which include but is not limited to patterns, trends, and correlations. And then we have, and I think perhaps is a bit of a peculiar European approach, two different exceptions, Article 3 and Article 4, which are very similar in many respects, but they also have marked differences. Article 3 applies to research organizations and cultural organizations acting for research purposes, and it cannot be limited by contract. So this is an exception for text and data mining that only benefits certain subjects, specifically research and cultural organizations. Is imperative in the sense that cannot be limited by contract. We have a specular provision, Article 4, which is available to potentially everyone, so every beneficiary could in principle enjoy this exception for text and data mining. But here there is the major element that we have seen already linked to the provisions of Article 53 of the AI Act of the possibility for right holders to opt out. So in this case, the provision can be, so to speak, limited contractually or by a declaration, an act of the right holders. And we will see how this can unfold. I think that is important to understand the conceptual framework of EU copyright law, to understand that we categorize text and data mining mainly as from the point of view of the right of reproduction. So Article 3 and Article 4 are exceptions to the right of reproduction. There is a slight expansion in the scope of Article 4, meaning that Article 4 is also an exception to the right of adaptation only with regard to software. There may be various reasons why, connected also to the process of harmonization of EU copyright law, which is very advanced but not yet complete. A part of these important differences is important to observe that both Article 3 and 4 possess the same definition, quite broad, are mandatory in the sense that this is a directive, so it is applicable by member states that have to implement it into the national laws of the 27 members of the European Union. So it is mandatory in the sense that it is not optional for the member state to implement it, but only Article 3 is imperative, meaning that cannot be limited by contract. I think it's also quite important to note that both Article 3 and 4 have a storage provision, meaning the possibility within the scope of the exception to retain permanent copies of the training material for the purpose of scientific research in the case of Article 3 and for the scope of text and data mining within the scope of Article 4. And this is a very important element if we look at the need that both research, but industry and the civil society as well have in gain more understanding, more transparency in the way in which text and data mining and, by extension, generative AI operate. There is finally an interesting element of lawful access on which I will return briefly later on that I think is also quite important to note in order to properly understand the working of Article 3 and 4. So these activities, these exceptions can only be lawfully enjoyed to the extent to which there is lawful access to the material that is used for the mining or for the training. And now, of course, by extension, we look at the AI Act. The AI Act has been recently adopted. It will enter into force very shortly. It has been a very long and elaborated process, taking into consideration, of course, also the complexity of the themes that have been discussed and addressed. I think that one main element that we should keep in mind, being us probably a group of copyright enthusiasts, and therefore, probably like me, you see copyright everywhere. As soon as you see, you have breakfast in the morning, you drink coffee, and you think about copyright, and there must be some copyright-relevant act connected to that. In the case of the AI Act, it's not really the case. In the first version of the AI Act issued by the European Commission, so the initial proposal that then, of course, went through different phases of analysis, copyright wasn't addressed at all. Copyright was completely absent from the first version of the Act, from the first proposal. It has only been later on, thanks to the work of the European Parliament and the Council, that certain copyright provisions have been introduced. But as we will see in the next slides, these are still very limited if we look at the overall structure and economy of the AI Act. We're talking about 120 articles, more than 100 recitals, several technical annexes, and copyright is really addressed in a handful of provisions. So I think it's important to understand that the way in which Europe has approached the regulation of copyright through the AI Act is, well, perhaps not what one would expect initially, considering how much attention from a copyright point of view we put on AI. It is only through an understanding of the interface between the Copyright and Digital Single Market Directive and the text and data mining exceptions, and how those, particularly Article 4, has been operationalized within the AI Act, that we can imagine how the resulting framework will work. And, but I will not enter into this discussion, the whole body of legislation that recently we have come to call data and digital legislation in the EU. This legislation perhaps is familiar to you. It covers the Data Act, the Data Governance Act, the Digital Services Act, etc., etc. This is all new legislation that has been adopted in the last 4 to 5 years. Does not deal directly with copyright or with AI. However, it has an enormous impact in the way in which the EU internal market for data has been redesigned. And because AI relies on data, copyrighted but also non-copyrighted data, the only way to understand this full picture is to see all this variety of legislation as parts of a common design. Relevant provisions of the AI Act, to me, of course, I go very briefly through them, and I thank the previous speakers to have done such a great job and a favor to myself to already introduce some of the topics. But I think that it is important to understand the approach of the AI Act in regulating AI. It is approached based on product safety. So the idea of excluding certain AI, banning it because it's too dangerous, identifying certain other AIs at high risk, and therefore they are permitted, however, they need to undergo certain specific requirements, regulating other types of AI that do not pose any significant risk, so limited risk AI, and eventually, and this is one of the latest additions, some special rules on general purpose AI, which capture also the concept of generative AI, and we will see that is within this subcategory that some relevant AI, copyright provision has been implemented. I think that is also quite interesting to understand certain elements of the AI Act that have to deal with the overall AI life cycle, we could say. More generally, I think it's, and just to give you an illustration to make you understand how the system of the AI Act will regulate AI providers and eventually also deployers, this regulation applies to providers placing on the market, excuse me, or putting into service AI system or placing them on the or placing on the market general purpose AI models in the Union, irrespective of whether those providers are established or located within the Union or in a third country. So quite powerful, one could even perhaps dare to say almost extraterritorial extension of some of the provisions of the AI Act. And we will come back to this one later on because I think it has a quite interesting potential impact on the copyright dimension. So how do we look at this interface between the AI Act and the copyright provisions? I think that Recital 105 does a quite interesting job in summarizing what is the overall strategy of the AI Act in this sense. Recital 105 says that general purpose models capable of generating text, images, and other content present unique innovation opportunities, but also challenges to artists, authors, and creators. Text and data mining techniques may be used extensively in this context. The CDSM directive introduced the exceptions, Article 3 and 4 that we have just seen, for the purpose of text and data mining. Right holders may choose to reserve their rights over the works to prevent text and data mining unless this is done for the purpose of scientific research, as we have seen. Where the right holders, where the rights to opt out has been expressly reserved in an appropriate manner, providers of general purpose AI models need to obtain an authorization from right holders if they want to carry out text and data mining over such works. So I think that this is a quite interesting summary of what is the intended interface between AI, including generative AI, and the role of copyright, including Article 3 and 4 text and data mining exceptions. And I think that is also a quite different approach than what we have seen in the presentations given by the previous speakers. More specifically, within that subcategory of AI that we have defined as general purpose AI, Article 53, and I can go a bit faster because, again, it has already been partially introduced, provides that providers of general purpose AI models shall put in place a policy to comply with union copyright law and in particular to identify, including through state-of-the-art technologies, a reservation of rights expressed pursuant to Article 4.3. So this is the perfect link between the text and data mining provision in the CDSM and the opt-out possibility for right holders and what providers, so the developers of general purpose AI system needs to do in order to comply with the AI Act. In addition, they have also to draw up and make publicly available a sufficiently detailed summary, and I think here you can see the dynamics of lawmaking, a sufficiently detailed summary about the contents used for training of the general purpose AI model, according to a template provided by the AI office. And perhaps in all this extremely interesting wording, one very interesting element is that of the AI office, which is a new agency and a new protagonist in the EU internal market landscape. It is being built in these days. There was only a few days ago an official communication by the Commission that the constitution of the AI office has started. There will be 5 different units, staff of more or less 140 personnel working on various tasks from enforcement to compliance to assessment, and including, very importantly here, the drawing of certain templates, such as the template that GPI developers need to provide in order to operationalize the opt-out of Article 4. So under this point of view, the role of the AI office will become extremely important. And then I think it's also interesting to note, since it has been already mentioned also by previous speakers, that in the case of other AI applications, so provider of AI systems, so more generally AI systems that do not necessarily fit into a specific category such as a high-risk AI, including general-purpose AI system, generating synthetic audio, image, video, or text, shall ensure that the outputs of the AI system are marked in a machine-readable format and detectable as artificially generated. So this is also a quite interesting element that sometimes gets a bit lost in the complexity of the AI Act, but there is a clear obligation to mark that content. Of course, as any self-respecting academic, I have my own graphical representation of what is the life cycle of text and data mining, machine learning, and the AI applications. This is intended to summarize the complexity of some of the legal provisions that we have analyzed and to underline how much under EU copyright law the various factual activities can really be summarized from the point of view of reproduction. So keep that in mind because I think it's very essential. Sometimes we don't make it so explicit, but from the point of view of EU copyright law, text and data mining, artificial intelligence, generative AI, from a copyright point of view, are almost exclusively an issue of the right of reproduction. Reproductions under EU law are defined quite broadly, perhaps more broadly than in other legal systems, so much that sometimes even temporary and transient copies in the decoder of a set-top box on your TV that needs to decode the encrypted signal and then send it to your TV screen, that temporary copy qualifies as a copy. It is excused by an exception, but that already qualifies as a copy. Because we need because we have such a broad definition of reproductions, we need exceptions for all these possible reproductions. However, this general overview that I gave you leads to both this, text and data mining proper from my point of view, so the ability, for example, to predict the next or the old pandemic before we even discovered that there was a new virus, just by analyzing the data set that were available on various type of flights and combining them with other type of information. And to be clear, to me this is not a copyright relevant activity. I don't think that copyright law should regulate this. And this one is a completely different output of what we call machine learning / generative AI / you pick it. However, both predicting the new pandemic before it happens and creating, well, you will tell me in a moment if you think this is a copy, but something that at least prima facie could be copyright infringing, they both follow almost entirely from a EU law point of view and also from a technological point of view, the same life cycle. It is only really here at the end, at the output level, where these two different, very different outputs, potentially copyright infringing, saving lives, distinguish themselves in terms of how we perceive them. And therefore, I think that a more accurate representation of this scenario, something that might be present somewhere in the lines of the AI Act and of the Copyright and Digital Single Market Directive, but it is not made explicit, is that we do have two different types of outputs. We have text and data mining, information which include but is not limited to pattern and correlations, and generative AI, flexible generation of content such as in the form of text, audio, images, or videos. And probably they deserve a different regulation because the results that they lead us to, the advantages for society or the threats to human creativity are completely different, treating them precisely on the same level because the technological process that we see here is so similar. I think is the paradox and the difficulty that the various legal systems worldwide are trying to tackle and have proposed different solutions. So this distinction is one that I think should exist, that might be possible to identify under EU law, but I think that at least at the moment, if we look at the face of the legislation, we really tend to most commentators tend to assume that the output is the output and the same regulation applies there. So here, I think that if you want to pass your bar exam, probably want to tell hopefully not ChatGPT, that the output is the output, but I think that there's a normative argument that can be done to distinguish text and data mining outputs from generative AI output and synthetic content. Very briefly, from a EU point of view, we have not to forget the various exceptions in addition to text and data mining. We have an exception for temporary acts of reproductions. We have the new text and data mining exceptions. We have the exception for research and teaching, which is, for example, the old exceptions on the basis of which before 2019, member states already introduced certain text and data mining provisions limited to non-commercial research. Earlier, the example of the UK was made. Back then, the UK, still part of the European Union, passed that exception, national exception, on the basis of 5.3a. We have the questions about the output. Are they reproductions? Are they adaptations? Is there a form of co-creation? We don't really address this from a EU law point of view, at least legislatively in the EU at the moment. And then, of course, we have the big questions of whether there is a copy in the model. And if we were able to open a model and to look into that, it is, of course, an act that requires a minimum of imagination. But what we have in there is simply a statistical distribution of information. Is this a copy? I don't know. I would tend to say no. But if this leads to this, does it mean then, therefore, it is a copy? Or should we argue that it is artificial independent creation, applying traditional human copyright categories? And then the question is honestly also whether this is obviously one of those situations where, you know, bad cases, made bad law. Because here, obviously, we can see that probably due to overfitting, there is even something that is intended to be, from the point of view statistical distribution, the Getty image watermark. But forgetting this, is this image a copy of this one? Because, of course, there are elements of similarities, but there are also many differences. The copyrightability of this image in the first place, the originality element is not that thick in the first place. So I think that, you know, to a certain degree, generative AI in general is challenging also our very same conception of what is a reproduction in this realm. We already faced this kind of question when the internet boomed 30 or 35 years ago. But now with generative AI, probably we are refacing the same questions, but on an exponential level. The same question could apply, and here are just a few examples, whether when I ask, for example, ChatGPT to recreate Mickey Mouse, and it tells me that, of course, this would be infringing, but it can teach me how to do that. And at what level of that description, because, of course, draw a mouse with big ears, etc., etc., okay, it's not infringing. But when you start telling me that, A defining feature are the ears are a defining feature. They are circular, and the position symmetrical on the top of his head. I mean, we are really entering into a literary copy of an image. Is that an infringement? If I ask DALL-E to draw it, is this an infringement? I think I would recognize Mickey Mouse there, but there are also some style elements that are different. If I ask, again, I use a champion, so our champion today is ChatGPT, but there are many other models, to write me a story in the style of an author. Is that a copy? Is that infringing? And we have seen just before my talk a very interesting analysis on that. And I think that here, again, we have these traditional copyright concepts whereby we don't protect genre, but there is an element of market substitution of the output that is threatening authors in a way that we have not known before. So I think that really what is happening here is that our traditional copyright categories are being challenged, and because the questions are new, possibly we need new answers. So again, in my very bubbly representation, I think that there are two elements that I want to cover in the last 5 minutes that I have. One is to give you a couple of examples that we have observed so far as interesting development in the opt-out. And I will say a couple of words very briefly on the element of lawful access under Article 3 and 4 and how it is connected to Article 53 of the AI Act. So I start with lawful access. Article 3 and 4, in order to be valid, need to be based on a lawful access, except that we don't know exactly what it is. The CDSM directive does not define it, but it gives us some information in the recitals. And recital 14 for Article 3, so the text and data mining done by scientific organizations, tells us that lawful access is based on open access policies, fine, through contractual agreements, clear, through other lawful means, fine, but should also include content that is freely available online. And I think, and together with me other scholars, the Commission much less, that this is an open door to distinguish on an infringement level what is the obligation of the agent, of the beneficiary of the text and data mining exception, and the fact that the only way in which Article 3 in particular can operate is to accept that the category of lawful access has to focus on the behavior of the agent, of the researcher in this case, and not on the status of the access source. In new copyright law, for the experts in the public, we have this concept of lawful sources, for example, that is necessary for certain exceptions such as private copy. We have other similar concepts such as lawful use that is necessary for Article 5.1, temporary copies. Here the legislator has decided, in my opinion, consciously not to use those categories that already existed in 2019, but to create a new one, that of lawful access. And I argue that the only way in which Article 3 can survive, so I argue it here, is that it must be possible to have access even to unlawful sources as long as the behavior of the researchers is lawful. So no infringement or no breach of contract, no circumvention of technological protection measures, that's clear, but we cannot ask the researcher, in particular the researcher, perhaps also Article 4, to verify the legal status of every single source for text and data mining or perhaps even generative AI purposes, because we're talking about hundreds of thousands of works that would need to undergo a specific clearance and copyright assessment every single time. And once they are present, if ex post we verify that they are there, there is also a connection with a different test that the courts more recently have developed that gives the possibility to create a presumption of lawfulness in case of non-commercial activity that Article 3 researcher could employ. But once this presumption is destroyed, for example, through a notification, we have to remove that content. But it's impossible to remove content, the information extracted from that content in a model. It would mean that every single time that notification arrives for hundreds of thousands of words, that model should be thrown away, the database cleaned from the allegedly infringing content, and the entire model retrained with the cost, economic, compliance, environmental that triggers. If that was the case, particularly for research organizations, this would mean there is no real viable option for Article 3, and this is a strong push towards licensing. It could be an option, but then we have to acknowledge that Article 3 becomes entirely irrelevant. And the final argument in the few seconds that I have left is that of the opt-out. We know the traditional robot TXT. There have been various proposals to use a similar technique. For example, WC3 has developed a text and data mining reservation protocol that gives the granularity to be able to extract specifically by web page or database which are the various works for which a reservation of right has been performed. And in the case of when EU law is applicable, then the advantage over the old robot TXT is that now this opt-out performed through an XML piece of code becomes legally enforceable because relies the way of operationalize the Article 4.3 reservation. There are obviously a number of problems that I don't discuss in detail. Subject matter, how to distinguish between 3 and 4. University, when you have several works available on the internet. How many opt-outs, what happens when you have contradictory statements because perhaps your work is present on 2 different websites. And the temporality, what about the old opt-outs or the training that has been done before the opt-out has been put in place. And the last argument that I want to make, just to conclude in my analysis, is that of spatiality. So what happens when, for example, the models are trained in a legal system that we could say is cheaper because it allows broader exceptions and limitations? Could there be a system whereby the training is done outside the EU and then the model is imported or the output is communicated to the EU? Well, quite interestingly, the recital 106 tells us that providers that place general purpose AI models on the union market should place a policy to comply with union law on copyright and related rights, in particular the opt-out, we know that, regardless of the jurisdiction in which the copyright relevant acts underpinning the training of those general purpose AI models take place, which means that if ChatGPT want to communicate their output to the EU market, in theory, they have to train their models following EU law, even if they are based in the US or in Japan. And I think this is an element of the AI Act that has so far not been explored substantially, but is something that could represent a big game changer because it represents a rather unusual extension of the copyright reach. With this, I thank you very much for your attention. Thank you very much.
네, 감사합니다. 토마스 마르고니 교수님께서 또 역시 EU
Thank you very much. Professor Margoni had given us a very insightful presentation about the European Union. And so the TDM exception and generative AI, the purposes in the end ultimately have to be differentiated at the output level. So we've heard from US, Japan, and also EU's responses to generative AI. It's now for lunch. And session number 2 is going to start at 1:30. So I would like to ask you to come back by 1:30. If you have any questions, please remember to use the QR code that's on the screen right now and input your questions. And we will collect them and we will deliver them to the moderator during the Q&A session. Please enjoy your lunchtime. Thank you.
네, 바로 이어서 2024
Now we would like to start the section number 2 of the Seoul Copyright Forum 2024. So we'll be talking about GenAI and copyright industry initiatives and finding the right balance. We'll be looking into the situations of Korea and also global responses, as well as find some right ways to find the right balance. So first but not least, I'd like to invite Mr. Moon-gi Lee, who's the director at Konan Technology, who's going to be talking about industry initiatives, local case, in the case of domestic Korean case, and the responses. Let's welcome Mr. Moon-gi Lee with a big round of applause.
네, 안녕하십니까.
Good afternoon, everyone. I'm from Konan Technology. My name is Moon-gi Lee. So I'd like to, first of all, thank the MCST and the KCC for giving me an opportunity to make a presentation at this forum. So I would just like to ask you to just be at ease, and the topic itself is quite a heavy topic, but I'm just like to share with you some of my insights regarding how to approach this heavy issue from an industrial technology perspective. So I hope that my presentation would be of help to you, and just approach my presentation with open mind. So we talk a lot about generative AI. So I'm not going to be talking about what GenAI is. Well, I will touch upon it a little bit in the latter part of my presentation. But let's just quickly look at what Wikipedia says about the generative AI, as well as the language model behind the generative AI technology. I think it was yesterday, or the day before yesterday, the former Twitter, or X, had a lot of memes shared. So when I write, AI does the cleaning, does the washing of the dishes, but that's what I had thought. But it seems that AI, which I thought was going to help me, was actually doing everything instead of me. So basically, AI is going in a direction that was completely not predicted. So if you have a robot that is able to listen to human instructions, then we would have that kind of AI. But for now, it's a bit different. The reality that we are facing is that we have generative AI and the relevant copyright-related issues. So I'm going to narrow my presentation to generative AI and copyright. And then in the third box, you see ANN. And then you have the ChatGPT 3.5, which is already getting rather outdated. And so, ultimately, the goal is the development of an interface that can communicate with people through text. So it's not what generative AI is aiming to do, is actually using the interface that allows people to communicate through text. If we have this in mind, then circumstances become different. So I also majored in NLP. But so right now we have natural language processing, but ultimately the machines are being developed to natural language understanding. And so this is basically what the NLP engineers are doing. So they haven't been able to attain it for the last 70 years, but during the past 2 years, the engineers have been able to develop an NLP that is able to do that. So how are we going to interpret these circumstances? I'm not going to talk about it just purely from the technological perspective, but from a copyright perspective. So, why is generative AI able to develop to the level that can communicate with humans? Actually, there is no answer. Nobody can actually explain how AI is to be able to do so. The president of the Hanbit Media said that there's a law of scale at play. The more the training data, the higher the number of training parameters and better the performance of AI. So when you talk about the performance of AI, it basically refers to the performance and the ability to communicate and understand human language. And the chatbots that were in being before AI, if you compare it with the current AI, there's an exorbitant amount of difference. ChatGPT apparently trained on 5 trillion documents. So it was basically using a completely different kind of training methodology, and it's quite surprising that we were able to attain this kind of level. And there was also a transition that had taken place from quantitative growth to qualitative growth. And using a certain method of training allowed the AI to better understand the instructions inputted by humans. But nonetheless, because we cannot clearly define this process, we call it an emergent ability. But like I said, nobody really knows how and why this kind of process is as it is. And so on the top you see the MRI image, and on the bottom part you see the deep neural network, which is the network image of the DNA structure. So you may think that it's quite similar, but anyway, you can see that the technology is developing up to this level. So let's look at some of the efforts that have been made by developers. I'll particularly like to focus on what Konan technology, my company, has been doing. So Konan, the name, comes from Korean Natural Language Analysis Special Interest Group, the SIG. And so we were established in 1999, so it's been about 25 years, and you probably haven't heard of Konan technology, but we have been developing natural language processing and a variety of related technology. So it's quite a small company, but nonetheless, we have been attaining a lot of copyrighted works. And for example, since 2013, we have been provided with news articles from the Korea Press Foundation, and we have also been analyzing a lot of data that has been collected by social media. So there was a GENIP, which was a data broker who we bought from, but then that was bought by Twitter, and then that changed to X. So from 2014 until 2023, we were provided with that kind of information and data. So it stopped in 2023 because Twitter asked for a price that's tenfold. And so from our perspective, it became costly, so we stopped using tweets. And also patent data has been pulled from Keynote. And in the downstream task, we also bought patent information from Keynote. And also from the publication side, I am not naming names here, but we did contact an association, and we said that we would be willing to pay for electronic books, but the negotiations didn't really go well, because I can't really talk about the actual amount, but say we said 1,000 billion Korean won. The association had about 100 copyright holders, then they would have to distribute the revenue 1/100th. But then if it was 100 members, that's okay. But if it's 10,000 members or 100,000 members, then it becomes a completely different story. So the association felt that distributing the set amount of revenue was just not viable on their side. And of course, there are many other kind of data that we can buy from the internet. But it's true that it's quite costly, and so it's just too expensive for us to buy all the data. But nonetheless, why did we buy all of this data? So we wanted to develop commercial services for R&D and for actual services, but to be honest, there are many limitations. So many people asked us, you're not that big a company, you're such a small company, but why are you buying and paying a price for all the data? But that's because our CEO indeed believes that using without permission is illegal. So that's why we thought that we had to buy all the data that we were collecting. But there are a lot of limitations and questions we were facing. There are so much data that we need, but can we buy all of the data that we need? So if you look at some of the issues related to commercialization, those related to price, and then those related to TDM, that's how I categorize the different issues. There are hardly anyone who can answer these questions. Are there sellers? Is there an acquisition process? Is there like a comprehensive agency for each media type? So is the data priced? Can the data be bought at any time? No. This is because data doesn't exist as a good that we can transact at all times. Is it possible to predict the BEP? Is it possible to estimate the expected returns? From the company's perspective, we do have to make predictions on the BEP and the expected returns because that's how we make a business case, and we also have to be able to convince our shareholders. Otherwise, the transaction is not going to take place. So TDM is an alternative that has to come up because of the reality that forbids us to acquire large amounts of good quality data. But nonetheless, we do need data. That's how TDM came into existence. Then what is lacking in this era of generative AI? Let's look at this issue from a broader perspective. So there are three essential elements in developing generative AI: data, GPU, and then you also need the developer. So first of all, let's look at data. When GPT first came out, around about 2018, there were about 117 million parameters, and the Reddit data was about 800 million pieces. There are no tokens in Korean. But then if you go to ChatGPT 3.5, the number of tokens became 300 billion, but the number of tokens in Korean was just mere 0.57 billion. How about Llama 3? The number of tokens is 15 trillion, out of which Korean was 25.5 billion. So it's less than 1%. It's something like 0. something percent. Then how about the Korean models that have been trained in Korean? So you have GPT and you have Naver's Hyperclover that you all know well. And so about 560.8 billion in total. But if you look at Hyperclover, it's about 4.4 tera. And so that's still very little, 4.4 terabytes. And so 50 years worth of news articles is there, which is a copyright issue. And there's about 10 years worth of block data. So Naver's model, which is huge for Korean standards, it's still, compared to global standards, very, very, very small still. Meta came up with Llama 3. It's a 50 billion model, which has a token of 15 trillions. And so if you talk about 15 trillion tokens, it's 120 terabytes in capacity, which is about 55 billion worth of pages in documents. And so from a typical Korean publications perspective, it's 3,250 years worth. So when we talk about 15 trillion tokens, about 5% are non-English data that had been collected from about 30 countries, and Korean is only about 205 gigabytes. So what's important is that Lemma does use Korean data. Where did that Korean data come from? Nobody officially gave it to Yama, right? But the Korean data is there. So that basically means that the Korean web data had been crawled. So what I'm trying to say here is that registered works alone is not enough to fulfill the data demand for training of AI, but nevertheless, high quality data is necessary. So there is a dilemma here. How are you going to resolve this dilemma? Now let's go on to the second element, which is the GPU. So according to Semi-Analytics in 2023, you have the GPU-rich companies and the GPU poor. So OpenAI, Google, Anthropic, Inflection, XMeta, MS are GPU rich. Koreans are not even in the GPU poor category, just doesn't exist at all. So about the Yama have about 40,000. And so it takes about 6 days to train 15 trillion tokens. Other speakers talked about preparing the data, training the model, doing the verification, and then fine-tuning the model. So you have the free training and post-training, and so you can, just express it in one slide. But if you expand it according to time, training can be 6 days, but it can also be 8 years. And you have to go through that entire cycle for you to be able to develop one model. So we also invested about 1,000 billion Korean won to invest in the different equipment. Of the 800 GPU, also Kakao invested a lot, and also Naver. So some companies only have to train it for 6 days and then make adjustments and maybe train it another 6 days. But how about Korean companies? We have to wait 8 years. Is that realistically possible? Maybe we have to wait 300 days in the case of Kakao. Naver only has about 800, 700 units, and so maybe it will take them about 1.6 years. So Korea is already lagging far behind. So this is just a comparison of the GPU performance out of those that are already in the market. So you have the H100 and A100, and so already we're going to have more chips. But these GPUs are already in very high demand, just cannot get hold of them. Then the researchers, well, I think the graphs on the right you can just refer to. There is a continuous brain drain. That also goes for Konan technology as well. AI-related competitiveness of Korea is deemed to be 7th globally. But if you look at the GPU and the data, and also if you look at the situation of the developers, there is very severe technological dependence. And the fact that data is borderless, and also the fact that in the case of GPU, there are hardware behemoths, and the speed of technological development is a matter of survival for the businesses. So if you think about all of these issues, they're very serious, and the government has to pay close attention to these factors. So Yama is not completely open source, but they are somewhat open. And then if you put a Korean layer on that, and then we can develop in a very short period of time a model that is able to process Korean. And it's quite good in Korean too. Maybe it might take a little bit of time in fine-tuning it, but it's okay. But then is it okay just to use the model? Are there no licensing issues? Not really, because it's already open. But when people say, is it okay to use that model, there's an issue of, they are mindful of the issue of bias. So the input data has to be accurate. It has to be not biased. But if a model was trained outside of Korea in Korean, the model cannot help but have a certain amount of bias. It could be something about historical perspectives. Say there is an issue, there is a question, then the answer to that question may not be so accurate. Actually, there is no way to check whether the answer that comes out of ChatGPT is accurate or not. People talk about hallucinations coming from ChatGPT. But if you're dealing with a whole lot of data, it's impossible to verify every single piece of data. If you can't trust the model, you have to verify it. But nobody knows the extent of the biases that the models are showing. It's impossible to verify, which is why people have no choice but to just use the models as they are. So I've been thinking about copyright. And here are some of the issues. In the beginning, I was very shocked. From a technology perspective, yes, we do have to respect copyright. We have been doing it all along in our company. But when I went to a relevant meeting, I had fingers pointed out to me because many rights holders or rights holders associations and from the legal community, all the developers and the technology related businesses were infringers. So there was so much negative talk that all the developers were infringing copyright. I think it was a Japanese professor, the speaker from Japan, who was the only one who talked about a more harmonious or win-win coexistence. Many other speakers were talking about the negative aspects of how technology companies were just infringing copyright. But if you look at it from both perspectives, you can see that there is a discrepancy and it's inevitable. So if you look at it from the perspective of the rights holders, it's a perspective of content. And so from their perspective, those who use or develop AI technology have very high risk of infringing copyright. But then if you look at it from the perspective of developers, well, we believe that it's the user's responsibility. It may seem irresponsible to toss all the burden onto the users, but all the input data is in numbers and it's dispersed. And so on the right-hand side, you can see the process of how an image is digitized and what's left is just a matrix of numbers. And then at the bottom, this is an embedding methodology where all of the words are converted into numbers in a high-level vectors and then expressed in vectors. In the previous session, there was a mention of the number that had come out of the trained data. So everything is numbers. From the right holder's perspective, many people are worried that the expected revenue is actually decreasing because AI is perhaps creating works. But that's not only the case for rights holders, it's also for developers as well, because AI is also coding rather than humans. And so developers are also facing some risk as a result of generative AI. But from the developer's perspective, we do want and we do call for an alternative so that we're able to strike a balance between the use of works and the protection of works. So on the left-hand side, you have right holders, and then the right-hand side is the developer. It's actually a ping-pong. You know, it's just going to be a never-ending debate because the rights holders will say that using training data is copying, and the developers will say it's not exactly the copying. It's just like indexing, and so it's not an easy debate to resolve. I think ultimately it's about remuneration, but for now there is no revenue. But every day the situation is becoming different. The OpenAI is apparently going to pay quite a lot of money as remuneration going forward. But I think we need to look at the infringement litigations from slightly a different perspective. So you have the rights holders, you have the developers, and the content service providers. There are about 23 cases between 2022 and 24. There are 3 cases where content service providers sue the developer, and there was 1 case where the right holders sued the service provider. Majority of the cases where the right holders were the plaintiff and the developers were the defendant. But right holders decided to attack the developers, not so much the content service providers, even though the content service providers were blatantly, in some cases, infringing copyright. Of course, in some cases have not been finalized as yet. The big companies may be able to pay the penalties as a result of the litigation, but small companies will probably go bankrupt. So let's see what the big tech giants are doing. So OpenAI has been signing contracts and deals with all sorts of different organizations. So has Google, and also there are non-disclosed schemes as well. So remuneration schemes are not really open, but it is deemed that Google or OpenAI is going to buy the news or the data that they're going to use. But the point is this: there are media groups that own the data or the news, and then there are also large rights holders. They are the counterpart in the trading. The smaller rights holders are sort of fading out and being isolated from the situation. But this is not what we wanted, right? The rights holders didn't want this to happen. But the reality is that the remuneration is being concentrated into a certain class of rights holders. Under these circumstances, is a win-win relationship possible? The answer is going to be difficult. The developers cannot move only according to the rights holders' interests, and it's not really possible vice versa either. But nonetheless, we do have to forge a win-win relationship. But the revenue projected revenue is not being realized yet. Korea seems to be lagging behind. Korean technology in the global market is being evaluated at 7th previously, but apparently the ranking of Korea is going to go lower and lower. If AI develops further and enhances human life, that'll be great. But there are two things from the technological perspective. If technology develops and the US is in the far lead, Korea can really lag far behind. But at the same time, if the generative AI becomes AGI, artificial generative intelligence, or may not go to the level of AGI, but then is not able to be developed, then there will be no further investment and there will be no further development of AI. AI is not up to the level of AGI. We don't know when it's going to reach the level of AGI, but nonetheless, we still have to continue to develop technology. We don't know where the end is going to be. So if we were to draw an ecosystem, the rights holders, the model developers, the service developers, and the businesses, and if we were to forge an ecosystem where all of these stakeholders can coexist, then the CMOs will be able to provide the various data products. The model developers or the service developers pay, but also the users. Users also have to pay remuneration. And we have to be able to set up this kind of scheme. Otherwise, copyrighted works will not be transactioned or traded properly. And so I am proposing this kind of ecosystem. This is inevitable because there's a lot of TDM data that has been used in training, but now we have not just the plain training, you also have the downstream tasking and the fine-tuning, and it's the latter part that is increasing. And so we need experts in various different fields. And so I think all eyes and attention are going to go towards publications. So this is why I am proposing this kind of ecosystem. Anyway, in closing, and I hope that we'll be able to strike the balance between the two sides. With that, I'd like to close my presentation. Thank you very much.
말씀.
Thank you very much for your insightful presentation. So we have taken a slight step backwards and looked at the position of Korea in the global market, and also we have talked about ways to forge a win-win relationship between rights holders and developers. Let's go on to the second presentation.
인공지능은 전문으로
The second speaker has been working in the field, specializing in AI for more than 2 decades, especially looking at IP and innovation, giving legal advice. We have Sonia Cooper from Microsoft, who is the Assistant General Counsel. Please welcome her to the stage with a big round of applause.
It's an honor to be here today at the Seoul Copyright Forum. I'm Sonia Cooper, Assistant General Counsel in the Intellectual Property Group at Microsoft, where I lead the work on IP policy. I'm also a patent attorney where I work closely with Microsoft Research in Cambridge, focusing on AI invention capture. So in my presentation today, I'll talk a little bit more about what AI is, and then talk about the role of copyright and the careful balance that it provides. And then I'll talk about ensuring how AI can work for everyone. Our mission at Microsoft is to empower every person and every organization on the planet to achieve more. The mission statement is reflected in our approach to AI. Microsoft is making huge investments in AI, and that's because we're very optimistic about what it can do to help people, industry, and society. And we're committed to responsibly realizing the promise of AI. And we have so many reasons to be excited. AI holds so much potential. It will enhance virtually every aspect of our lives. It can improve productivity and stimulate economic growth. It will help people be more creative and innovative. The ability to discover new insights from vast data sets will drive new advances in medicine, new frontiers in science, new improvements in business, and new and stronger defenses in cyber and national security. It will help us discover treatments for cancer and help us reduce carbon emissions. And this is just the beginning. As the rate of innovation accelerates, we'll see even more impressive applications. So how does generative AI actually work? So generative AI allows people to create new outputs. So these can be images, text, videos, sounds, but they can also be non-creative outputs. They might be molecules or new materials. So we're not just talking about creative outputs. AI models that are used in generative AI are trained by using vast amounts of data, as we've heard already. For text, data is tokenized, meaning that it's broken down into small units that are fragments of words. AI models are algorithms that take numbers as inputs, not words. And so they're converted into numerical vectors by word embeddings. And these represent the words in latent semantic space. So if you look at the slide at the moment, the vectors capture the semantic and contextual meaning of the words and their relationships to one another in the vocabulary. So this enables the model to understand the relationships between the words when it's trained. So for example, dog and cat may be relatively similar as they're represented by vectors. So the words are broken down, they're turned into numbers that represent their relationship and meaning, and then the model is then trained on these numbers, where it starts to learn the relationships and concepts on a vast corpus of training data. And developments in the way that training data, or rather training methodologies, have advanced means that you can now use self-supervised training techniques, so you don't have to label the data, and that's actually given rise to the ability to train at the scale that we're seeing, and it really is the scale of the training data that's the reason behind why we're seeing such incredible advances. So once a model is trained, it no longer uses the training data to perform its tasks. Instead, the model is able to make predictions to generate outputs based on the patterns and the concepts it has learned, and it really is the patterns and underlying concepts that are important. So after the model has been trained, and when the model is used, the model can then be used to predict the next likely most, or the next likely most output. As the text generator can generate the next word in a coherent sentence, you can apply this to other types of outputs. So for molecules, you might be able to predict the next chemical bond or atom based on the relationships between molecules that the model has learned. So how will it be used as an accelerant for innovation? AI will probably be the most consequential technology of our time, not just because of the incredible understanding and reasoning abilities that we've witnessed over the past year that some thought we'd never see, but because of how it means that we now can approach innovation. It's not a standalone technology. It's a foundational development which accelerates our ability to not only innovate more, but to understand more. And it represents a paradigm shift in our ability to learn, understand, discover, and create. This new paradigm in understanding has formed the basis of Microsoft's AI for Science group at Microsoft Research. So if we look back over the historical development of scientific discovery, the first paradigm was purely empirical, based on direct observation of nature. The second paradigm was characterized by theoretical models of nature, such as Newton's laws of motions or Maxwell's equations of electrodynamics. Derived from analyzing empirical observations, this understanding allowed us to predict the behavior of some systems. The third paradigm was really the introduction of computers that enabled us to apply our understanding to large amounts of data. Early machine learning formed the fourth paradigm of scientific discovery, allowing us to analyze vast volumes of data of experimental scientific data to identify new patterns and enable these theories that we developed. But they were still not soluble. It was still impossible to really try to fit together all of the various variables that you would have in that scenario. But over the last year or two, we've seen the emergence of a new way to exploit deep learning, both in its application to scientific discovery and more generally. These multi-dimensional high-parameter models, or foundation models, are able to learn from the training data that includes our understanding of the world. So it's not just learning from empirical data. For scientific discovery, these models allow us to get closer to unlocking solutions from a vast problem space. Better medicines, better materials for capturing carbon, better predictions for complex weather systems. By training on the data that includes our understanding of the world, you're essentially collapsing that problem space. In the same way, text generation that was previously based on patterns that relate to syntax and context is now able to be based on a deep understanding of concepts from the training data, which enables conversational interfaces. And this presents a huge opportunity for furthering innovation across all areas of technology. AI extracts patterns and concepts and can apply these to new domains to solve new problems. And they have an amazing ability to actually integrate disparate concepts. So in the example shown here, we demonstrate how a large language model was able to produce a proof of the fact that there are infinitely many prime numbers in the style of Shakespeare. So here, a combination of domains that the training data would rarely include, so literature and maths were picked. So this example demonstrates that not only these models can understand the underlying concepts from the training data, but they can also apply them and combine them effectively. And it's these capabilities of large language models to extrapolate concepts and to apply them in new domains as to why they are important in science and innovation. So here's another example to illustrate this point, and this is DeepMind's alpha geometry. Alpha geometry is a system which has been developed to master complex geometry problems. Geometry requires creative problem-solving skills. The prevailing AI approach for geometry lies heavily on rules crafted by humans with symbolic deduction engines. While effective for simple problems, symbolic deduction engines encounter difficulties in flexibility, especially when handling new scenarios. So this approach is slow and inflexible. Creating exhaustive rules for every conceivable situation becomes impractical as the problems increase in complexity. So the alpha geometry solution harnesses capabilities of two distinct systems: a large language model, which is good at recognizing general patterns, and the symbolic AI system that applies these rigorous rules. And so the large language model is trained with humanly readable geometric proofs to enable it to guide the symbolic deduction engine towards likely solutions. The ability of AI tools to learn and apply concepts to solve problems already has a wide application for innovation. But we're just starting to unlock this enormous potential. But here are a few examples. So in the area of accessibility, patterns are learned during AI training. And these patterns play a crucial role in actually being able to develop accessibility tools. So seeing AI is one example, and this is an example that we've had for a while, but is continuing to develop. And so this is where machine learning models are able to identify and provide audio descriptions of real-life images for people that are visually impaired. And that relies on these models being trained on vast amounts of image data. Techniques using generative AI can also speed up discovery of new materials. So consider the application of generative AI in material science. The Microsoft Quantum team and the Department of Energy's Pacific Northwest National Lab in the US have used AI to screen over 32 million candidates and to discover and subsequently synthesize a new material that can reduce lithium use in batteries by up to 70%. Using generative AI, we were able to identify a new material that was previously unknown and not present in nature. The reduction in lithium could have tremendous effects for the environment, safety, and economic benefits. And without the use of AI, this could have taken a lifetime to discover rather than just a few weeks. In the field of cancer research, Microsoft Research has developed a number of tools that could enable radiologists to more easily identify cancerous tumors, to delineate tumors from healthy tissue for scans during radiotherapy treatment. Such models need to be trained on a large amount of image data. But also large language models have a role to play in the conversational interfaces that can be used by doctors to explain areas in the image that need radiologists' attention. Most recently, Microsoft Research and Cited have collaborated to build a novel AI model to scale the early detection of esophageal cancer. And that can reduce the pathologist's workload by up to 63%. In the field of pharmacology, generative AI models are accelerating drug discovery at an extraordinary rate. New drugs can be developed by predicting the properties of new chemical compounds from information that we derive in scientific publications. Scientific publications that are publicly available are a very important resource for training these types of AI models, and they enable rapid drug discovery. Without the ability to train on such copyright works, we will directly impact our ability to apply this technology to help cure diseases. And as one data point that is really important to consider, in 2010, medical knowledge doubled every 3.5 years. Today, with AI, projections show that medical knowledge is doubling every 73 days. So generative AI is a predictive algorithm that does extremely sophisticated maths. It's a tool that's being used by humans. It can't do anything on its own. It's not a replacement for humans. Instead, at Microsoft, we use the metaphor of a co-pilot to emphasize that it's a tool that assists humans. Generative AI is a way to identify knowledge and insights from extracting patterns across a vast volume of data and then make them more accessible and usable for everyone. It's not a copying machine. In fact, the models are designed specifically not to copy existing information, but to generate new information. And it's not a database. The model doesn't contain the data. It contains a matrix of billions of parameters built from learning patterns across a vast data set. But it doesn't contain the data itself. And it doesn't need to refer back to whatever data was used to train the model in order to operate. So now let's look at AI from the copyright perspective. The core promise of AI is that it can help humans learn. And as I've explained, it can identify patterns and correlations that help us make sense out of vast amounts of existing knowledge. But the advent of AI has led to a renewed debate about the right of humans to use machines to learn from copyright works. Critics generally concede that humans have a right to learn from copyrighted materials, but they object to these concepts being extended to machines, mainly out of fear of the impact on their livelihoods. But as we've seen before, this happened in the printing press, as the earlier speaker mentioned. Modern copyright law emerged with the invention of the printing press. And much like AI today, the printing press unlocked the ability to share information widely and rapidly. This greatly accelerated knowledge and scientific advancement throughout the world. Through copyright protection, authors and artists are able to prevent the copying of the expression of their works. But it's very important that this right doesn't extend to protecting the underlying concepts and patterns. Because if it did, that would prevent humans from learning and developing knowledge. And this is made clear in Article 9.2 of TRIPS. Therefore, copyright protection should not actually prevent humans from using AI to understand concepts and patterns and correlations in the works that they have access to. The AI copyright debate has focused mainly around three questions. Should we allow training on copyright materials? It is not and should not be a copyright infringement to analyze these works, to learn from works that you have access to. To use the learnings to create something new, this is all clearly fair use. But what do we do about AI outputs that may infringe copyright? When the expressive content of a work is copied, so when there's a substantial taking of a work, regardless of how it's created, using AI or otherwise, this should be considered a copyright infringement, and rights holders should be able to rely on copyright law to prevent this. And then the last question we're seeing is, are AI outputs entitled to copyright protection? AI is a tool like any other that can help humans create. And just because AI is being used, this should not prevent a human who has used AI to create the work from being considered an author. The legal discussions, particularly around training on copyright works, have significant policy implications. Broad access to training sets are key to unlocking AI's full potential. They make AI systems perform better, safer, and be less biased. Broad access to copyright works is also the best way to ensure that everyone can advance in AI innovation, not just the biggest companies with the deepest pockets. AI will not be available for everyone to develop and use if there are exclusive rights to data or an equal access to data. Data should be available on fair and equal terms to all parties. Both of these policy considerations are grounded in the fundamental principle of copyright, which is to promote the progress of science by ensuring that creations are shared. While we think it's important that the analysis of works to train AI is not prevented by copyright, we recognize that creators want to control their participation in AI, as well as understand how they can benefit from AI. Microsoft supports the ability of rights holders to control or restrict the access to data for AI training. So we want to allow creators to put content behind a paywall or otherwise technically restrict access, to use machine-readable means such as robots.txt to indicate that they do not intend their content that they make publicly available to be scraped, and to allow rights holders to use controls to indicate their preferences about the use of their content, both in our Copilot tools and when we use that content for training AI systems. We also recognize that more can be done in this area, so we support industry efforts to standardize an approach that gives rights holders the choice to restrict the availability of their works in AI training. So, in short, we support the ability to opt out. So controlling outputs, it's rare that an AI model will output something that infringes copyright when it's used in normal operation. But Microsoft and other developers incorporate technologies into our products that prevent the output of potentially infringing works. So we use meta prompts and filters to control the underlying model behavior and reduce the risk of outputting third-party content. Also, and this has been in response to feedback from the creator community, the new Bing image creator gives living artists the ability to control how they participate in AI to prevent the use of their name to generate outputs. We've also rolled out the customer copyright commitment, in which Microsoft has agreed to indemnify commercial customers. We'll defend them and cover liability that stems from copyright infringement claims as a result of using our tools. But this is provided that the customers have implemented our required guardrails and mitigations. This further protects rights holders by encouraging our users to use tools responsibly, and also provides awareness around some of the copyright issues amongst our customers. AI gives rise to new applications to support human creativity in unprecedented ways. Our view is that the human author should be able to secure copyright protection for their works, regardless of what tools they have used in the creative process. Human talent and creativity should not and cannot be replaced. Art is fundamentally about human connection. And policymakers should ensure that humans continue to be at the center of AI development or art generation. Beyond copyright. So, as AI applications develop, there may be economic disruption in certain categories of art and writing. However, copyright law is not the right tool for dealing with this disruption. Humans will create works in new and exciting ways, so jobs may evolve, and we see this with the advent of any new technology. And so policy initiatives should support skilling. And Microsoft is committed to investing in skilling initiatives globally. Our commitment to developing AI that works with the creative communities involves a continued dialogue with rights holders and artists. This year, Microsoft was the official partner for the 77th Cannes Film Festival, where we were able to engage enthusiastically with attendees. AI is clearly a tool to be used by human creators. Our tagline at the event resonated well. AI is not creative, you are. The training of AI models is not a copyright infringement, and therefore it does not require licensing. However, new markets, business models, and other opportunities for data providers and rights holders can flourish as a result of AI development. So going forwards, let's keep in mind where we want to get to with the IP system, in that it continues to provide balance to support innovation and incentivize human creativity. We should not try to extend the boundaries of copyright protection, and we should preserve the balance that it affords. We should recognize the human contribution in using AI as a tool to best understand how the IP framework applies and to keep humans at the center of innovation and creativity.
네, 큰 박수 부탁드리겠습니다. 네, 이렇게
A big round of applause for Ms. Sonia Cooper. She covered the principles of AI, all of the endeavors and investments surrounding AI, and Microsoft's policy and stance regarding the issue. I guess we are hearing a slightly different tone compared to the first session.
하겠습니다.
So the last presentation is going to be made by Professor Sang-Yuk Cho, who's a professor at the Kyungpook National University School of Law. He has been teaching IP-related laws and is going to be talking about finding the right balance between AI and copyright. Let's welcome Professor Cha onto the stage with a big round of applause.
예, 안녕하십니까.
Good afternoon. As was just introduced, my name is Sang-Yuk Cha. I'm a professor at the Kyungpook National University School of Law, and I teach IP law and IT law as well. So So today, my presentation is going to be about the rights holders and the AI users and also the AI businesses and how the legal interests should be striking a balance. So this is the table of contents of my presentation. So first of all, who are the stakeholders of generative AI? Then I'm going to be talking about the balance of legal interests while using of the training data, and also the balance of interests whilst disclosing the training data, and the balance of interests regarding the labeling of AI output, the copyrightability of AI output, and also the issue of copyright infringement by an AI output and the different types of output and how that kind of output is deemed to be infringing copyright. So I think everyone has already talked about the different stages of approach, and everybody knows that we need to differentiate the different stages. We have machine learning, we have deep learning, and then the AI is able to create a copyright ecosystem that will completely unpredicted. And so we can differentiate the AI developing and training stage and the AI output producing and exploiting stage. And the relevant institutions and the relevant laws that apply to each of these different stages can be different. So let's look at the stakeholders of generative AI. So first of all, we have the rights holders and as well as the holders of neighboring rights, but like performers and authors. And then you have the developers of AI models. So they are the developers who actually perform the machine learning or deep learning. They're mainly businesses, but not necessarily. And then there are the users of AI models, the service providers. So these are the mediators, and they are creating the relevant market. So they could be individual users and also businesses as well. And then there are users like you and me. You have the individual end users, mostly individual. But there are also businesses looking for new different revenue models. First of all, let's look at the holders of copyright and also neighboring rights. So rights holders are concerned that their works will be used without permission. And if infringing material are created en masse, then how are the risks going to be eliminated? Because these kind of materials are produced illegally, but then they're going to be distributed illegally as well. And so then there are no borders. These kind of pirated materials may be uploaded to websites outside of Korea. And what's going to happen then? So these are some of the concerns that the rights holders have. So if you look at the guide on generative AI and copyright that was published at the end of last year in Korea, there is also the differentiation between the training and developing stage and the output producing and exploiting stage. And so there are some guidance that is given to right holders depending on the relevant stages. So, for example, it advises that the robot exclusion standard can be used, or the rights holders can opt out, or make explicit statement that they don't want their works to be used. And also, there is some guidance of some kind. There's guidance on some legal recommendations on how to come up with institutions that can actually prevent the infringing of copyright under these circumstances. So these contents are all in the guide that was published at the end of last year. Then you have the AI developers. So they're the sort of the programmers, you could say. And then you would have the businesses that recruits and employs these programmers. So they have a dual position. So when it comes to the trained model, they are the rights holders over that model itself. But then on the other hand, the developers or the programmers can be the users of copyrighted work when they train a particular AI model. So they are the users, but also they are also the copyright owners of the model itself. They are also concerned that they may use our copyrighted work without permission, and then they are also concerned that the rights holders might file a claim against them for copyright infringement. And then there's a system service provider like the ChatGPT or Google Gemini. So you have the AI service providers. They also face a lot of legal risk and uncertainties. So whether it be AI developers or system service providers, they are very much interested in the exceptions, and they do want to be free from the liability, or they want safe harbors in place. And then if you look at the guide on generative AI and copyright that was published in Korea, once again, there is a differentiation in giving legal advice depending on the different stages of developing and training versus the output producing and exploiting. The user is also in a dual position. There are more individuals than businesses, in fact. So an individual may feel that, okay, I was just using a service, but then if I am facing a copyright infringement litigation, what am I going to do? If I get a copyright claim, what am I going to do? I made something using AI, and if it's a content that cannot get any legal protection, how am I going to be rewarded for all the effort that I had invested up until now? So these are some of the concerns of the users of AI models. So you have the staged approach. So in the use of training data, many people talk about some of the legal issues surrounding the TDM exceptions. So if you look at the different models, you have the large language models, and it's more like writing and learning. And so it's not really easy to fulfill the criteria of having an access to original work. But when it comes to GAN models or diffusion models, they're not like LLM models. They also manifest very expressive kind of elements as well. Therefore, there are images and various visualized material that are used in the diffusion and GAN models. And so there is a higher likely that the developers will face a litigation for copyright infringement because of the output. Then you have the retrieval augmented generation, the RAG technology. The RAG technology technology-wise is a little bit more understandable because it enhances the factuality and the contextual understanding. And so basically it uses a database to enhance its training of the knowledge base. But then external databases can be used, and then there may be copyright works included in the external database. And so the RAG technology also is not free from the dangers or risk of copyright infringement. Then there are the LoRa, L-O-R-A models, the low rank adaptation models. So if you look at the model itself, it's a parameter efficient fine-tuning technology. And so in some sense, it's not really expressive. But then it can combine with a different model, rendering an expressive kind of output, leading to some copyright-related issues. We have already looked at the EU AI Act and also the Digital Single Market Directive. But then the interpretation around the legal access is under quite a heated debate. So legitimate access regulations are also in the Korean law, Article 48.1 of the Information and Communications Network Act. It's actually specifically referring to hacking, but basically this kind of access is not allowed at all times. But if you look at the judicial precedents, various circumstances are taken into consideration. So crawling, scrapping, and milling, and all these kind of actions are not deemed to be legitimate. Even if there are exceptions from the Copyright Act based on various other acts, including the Civil Act, this kind of action can be regulated. And so maybe regarding crawling and other kind of automatic collecting, there may be some measures taken on by the Korean government. And indeed, the Korean government has already had a previous stance regarding this kind of crawling and automatic collecting and internet websites, etc. But basically for now, there are plans to amend the KCA to allow for this kind of access. There is now the issue of remunerating the rights holders or the data owners. And there is a class action in the United States against the ChatGPT that is worth noting. For example, they're calling for an AI monetary fund to be established and also an AI council to be established. And there is also the issue of the technological protection measures. So regarding the EU AI Act, you have already heard in detail from many other speakers, namely Professor Margoni. Thank you so much for your explanation. Actually, on the right-hand side, you see this pyramid based on the risk levels. So the EU AI Act is risk level based. So it differentiates the different risk levels to four. Whether it be data and copyrighted works, the unpermitted use is forbidden. So there are unacceptable risks, and then that are completely prohibited, and then there are high risk level where conformity is assessed, and then limited risk and the minimal risk. What we are interested in is the trained data and the disclosure of trained data, especially pertaining to limited risk. So this yellow level is of high interest. And then if you look at Article 53 of the AI Act in European Union, it says that a summary about the content that have been used for training has to be made public. So there is a transparency obligation for the limited risk. But is it going to be up to standards expected by the rights holders? No one knows. How this law is going to be enforced, we will have to wait and see. But nonetheless, there is a transparency obligation. And ChatGPT had already gotten rid of and removed all the training data. So for now, the rights holders do now have a tool or a channel to access whether their work had been used. So what is the implication of this transparency rule? It allows for the rights holders to effectively exercise their opt-out right to the TDM exceptions as stipulated in Article 4.3 of the DSM directive. So what's the implication of this EU AI Act's transparency obligation? So when training AI, the training data, once the training is finished, cannot be verified for existence. It's like a black box. We don't know whether it exists or not. The parameters are left, and maybe some fine-tuning parameters are left. You can't really verify whether the training data remains or not. And so from the rights holder's perspective, they may file litigation. And so if we have the transparency obligation, there will be less of a burden on the rights holders when they file a litigation. But there is also a negative aspect as well. So everyone is concerned about copyright, so everyone has to disclose everything, which means that it's really difficult to get proper training data, and therefore the quality of the output from AI will be compromised. So this is the concern raised by the AI industries and community. So the transparency obligation from the legal interests perspective is, first of all, is regulating AI that is used as a tool. So it provides a legal framework whereby the AI can be used as a tool. And so, but nonetheless, we are faced with many tasks going forward. So I usually dealt with environmental liability litigations, and I studied this during my master's degree course. And so you have the polluter, and then you have the victim. It's really difficult to prove the polluting channel. And so the perpetrator or the defendant has the burden of providing the proof regarding pollution. And so, just as the burden of proof is transition in the environmental liability litigations, by mandating the transparency, like in European Union, there is a transfer of the burden of proof from the victim to the infringer. So, well, I can't really say whether this is going to be legislated or not, but I think there is going to be the effect of transitioning the burden of proof. So now going on to labeling, the European has the AI Act, the Chinese have theirs, the United States have a certain amount of labeling obligations, and also Korea also does recommend labeling. And so right now the trend globally seems to be that there is labeling. And also the Korea Communications Commission, as well as MCST and KCC, as well as the National Assembly, have all come up with some sort of a rule on labeling of AI content. But is it going to be mandatory? That is a different issue. What's going to happen if you don't comply and you don't label? Then the consumer confidence will be deteriorated. And labeling will enhance reliability and consumer confidence in the market. And also, ultimately, humans can become subordinate to machines. And so that's another rationale behind the need for labeling. So there's a lot of interest being paid into labeling. But anyway, to protect consumers and in order to enhance the transparency, I believe this kind of labeling is very much needed, and I completely agree. So who should put the label? I would say that first and foremost, those who run the risk of infringing should have the priority, or should first of all be the ones to bear the burden of labeling the content, because they can be the ones liable for direct infringement and also indirect infringement as well. So those who have the risk of infringing should be the ones to label first and foremost. Then there is the copyrightability of the AI output. I think this topic has been dealt with many times. I think you're all familiar with this case involving Dr. Stephen Thaler. In the US and also in the Korea, the courts cannot accept this kind of project. So I think Dr. Thaler was also considering this kind of litigation as a project. He was experimenting in a certain way. But I think we have enough jurisprudence to be able to respond to this kind of AI output and the copyrightability. Under the current law, it's impossible to recognize the copyrightability of this kind of image. Creative machine cannot sign a contract, cannot recruit people, even if we were to consider it as a work made for hire. And so, yeah, the decision was quite obvious under the current or existing copyright regime, at least. Regarding the AI output, there are two judicial precedents that I think we need to look carefully into. So regarding the AI output, the users, of course, want his or her rights, which is why the user would also want to file for registration of the copyright. In the Zarya of the Dawn case, there was this image, illustrations, and then there's a text. So the images, which were created by AI, with no intervention by humans, and so copyright was rejected. But when it comes to the text and when it comes to the selection of the images and the compilation part of the images and the text, the copyrightability was recognized. And then there is a similar kind of case in China, Li and Liu case. In this particular case, various prompts were used to get the image, the last image. And the user who created this image was actually granted the right to this image. So let's look at the jurisprudence between the two different cases. The USCO said that it's made by AI entirely, not by a human, and so the image is not a work, cannot be protected by copyright. So the human had inputted the prompt, but the image was not intervened at all by humans. It was made entirely by a machine. So the output and the prompt does not have a relationship that can explain or rationalize the copyrightability. On the other hand, in China, there was a certain amount of intellectual achievement that had been inputted, and there was some originality involved. And so the Chinese court ruled that in this particular case, it did fulfill some of the criteria that allowed it to be a copyrighted work. Of course, and then there was many different phases and steps of prompting and adjusting. So you have stage 1, 2, 3, and 4, and all of these images were submitted to the court, and the court eventually ruled that there was some intellectual achievement. So when it comes to GDPR and privacy, there was a huge conflict across the Atlantic. But nowadays, the EU AI Act and the US Copyright Act is facing a big discrepancy, and also across the Pacific, there is rather a big discrepancy in its decisions from the Court of Law. So how about Korea? What's our stance going to be? I think we have to be objective, and we have to reflect once again on what Korea's stance is going to be. So from the legal balance of interests perspective, there are various challenges going forward. So when it comes to visual images, how much of a human endeavor are we going to recognize and accept? That, I think, is going to be a very essential question that the courts will deliberate upon. So, but then this is only when AI is being used as a tool. But then maybe in about 5 years from now, maybe in 2030, you're going to have a strong AI. You're going to have general purpose AI. What's going to happen? Of course, the weaker AI is not going to disappear. The strong AI and weak AI are going to coexist. And in those circumstances, there's going to be a lot of content created entirely by AI. There's going to be content created or generated by strong AI and also weak AI, and a mixture of both. And so the copyright ecosystem and the content ecosystem is going to be much more complicated. Will these jurisprudence apply even then? That's the question. So anyway, Zari of the Dawn is recognized as a compilation, and we have a similar kind of case in Korea as well. So there is a ruling regarding compilation, that some aspects of a compilation work will be recognized for its copyrightability. So there is a debate around the copyrightability and the need for protection. So there are pros and cons. So whether copyrightability can be recognized, and whether the law should be protecting copyright. So in some cases, it seems that in some cases in Zara of the Dawn and some other cases in Korea, the text part was recognized, whereas the image part not. So I believe that this kind of debate is going to continue for the foreseeable future. And then there is also the issue of the specificity of the instructions given to the generative AI, the level of prompts and inputs, qualitative and the quantitative amount of instructions and prompts, how many times the prompts were inputted, how repeatedly, was there a selection and arrangement of the different inputs and prompts? And so all of these factors will have to be considered. So we have heard from a speaker that there are about 30 different litigation cases. So we can look at what happens. There is the expressive use versus the non-expressive use. And then if you look at the KCA, there's also a provision regarding whether fair use provision can be applied. And then the substantial similarity and the dependence or the access, I think you all know. When it comes to access, of course, there might not be awareness as to whether copyrighted works were included in the training data set. But anyway, if it's not apparent, it's really a case-by-case situation. And so the existing judicial precedents will also apply in this case as well. Then there is a direct liability and the indirect liability. The user can have indirect and also direct liability, as well as the AI service provider. Regarding technological measure, yes, they are necessary. And indirect liability can also be an issue. And we have seen it in the Soribada case. There is the aid and abet, whether the aid and abet kind of argument can be established. But if there were preventative measures, then that would have to be considered. And also, not just a priori preventative measures, but preventive measures post the fact. Cover songs are a bit of an issue. These days, you have in Korea with the Pamyang case, where a singer's face and the voice was covered by somebody else's voice, and then that video was distributed in YouTube, recording a huge view numbers. So you have the copyright holder, you have the neighboring rights holder, and they claim copyright infringement as well as neighboring rights because the works were used without permission. As for the performers, it's really their right to publicity that had been violated from the performer's or the singer's perspective. And we have heard about the U.S. situation in the Congress and also in the Senate. The federal legislations are being proposed regarding the fake replicas. And so it's a slight difference from the laws that we have in Korea. So we'll have to keep an eye on what happens in the US because in Korea there is also a lot of debate about the need to adopt publicity rights and protect publicity rights. So I would just like to close by saying that it was a human-centric perspective of AI, but about 5 years later, there's going to be a strong AI, and everything is going to be viewed from the AI perspective. And then maybe a decade from now, there's going to be a super AI. And I think the circumstances will be completely different, and the AI output also will be quite different. But the copyright law is still going to consider AI just as a tool of human endeavors. Thank you very much for your presentation. He has talked about the Copyright Act, and I think he has basically covered all possible issues that can arise between copyright and AI. So it was a very deep technological and legal analysis that he had made. Thank you very much. We have heard from the keynote speaker as well as 6 presenters. So I'd like to thank all the speakers once again, and a big round of applause for all of them. Thank you. Thank you. So next we have a Q&A and discussion session coming up. If you have any questions, please use the QR code on the screen in front of you, and then we will deliver your questions to the moderator of the discussion session. So we're going to have a short break, and then we'll go on to the next session. So see you in a few moments. Thank you.
네, 지금부터 약 60.
For the following hour, we will have a Q&A session and discussion. When your name is called, please come up to the stage. First, we would like to invite Professor Chul-Nam Lee from Chungnam University School of Law and Professor Tae Lee of Korea University, Mr. Darren Pogoda from USPTO, Mr. Yukihiro Miwa from Japan ACA, Professor Thomas Margoni from KU Leuven, Director Moon-gi Lee from Konan Technology, Ms. Sonia Cooper from Microsoft, and Professor Sang-yuk Cha from Kyungpook University School of Law. Please welcome them back to the stage with a big round of applause.
Let me kindly invite once again all the participants to the final panel discussion session. 네, 마지막 분께서 함께 해주시면 바로 토론
Once we have everyone up on the stage, we will begin the panel discussion. This session will be moderated by Professor Chul-Nam Lee, who teaches copyright law, motion picture broadcasting, media law, entertainment law, and IT law at Chungnam University School of Law. Then the floor is yours, Professor. We will now begin the session. Good afternoon. I am Chul-Nam Lee. I felt like this was too huge of an event for myself to lead, and I wasn't able to turn down the offer, so now I'm given this role, and I felt very responsible, so I prepared as much as I could. My role is to lead an active discussion. I had a chance to look at the presentation materials in advance, and I came to realize there was much to be discussed among the presenters, and there were blanks that could be filled by the fellow presenters. And we have many questions coming in from our YouTube channel and from the audience here. So we will have a Q&A session. Most of the questions are directed to a specific panel. So once we first cover those questions, we will open up the mic to the floor to entertain more questions. Well, personally, 30 years ago when I was a grad student, I was originally a law major by training, but I was very interested in computers, and there was a AI boom, which wasn't data-based, but for someone coming from law, for example, how the professional system in the legal realm would be formed was what I was interested in, and I was very much interested in translator systems. And there were a lot of attempts at the time, but the task seemed to be too daunting, so the boom subsided. But my interests in AI were once again piqued as I saw the evolution of Google Translator. And I saw a lot of advancement in the past 7 to 8 years. So RNN, transformer, newly emerging technologies seem to be very interesting. The new methodologies that imitates the human neurons, those led to great advancement of technology and led to superior quality translation outputs. And when it comes to copyright, entertainment, IT law, those are my expert fields. So I'm always very interested on how the relevant technologies released by Google would have an impact on those industries. Not only Google Translate, but CNN have greatly developed the vision technology. Images are converted into vector values, and they can be computed. What I remember is dog minus tail plus cat tail. So in the vector value, the dog tail is subtracted and could be replaced with a cat tail. And if you translate that vector back into an image, then it really produces an image of a dog with a cat tail. And the RNN technology was extended into music, where AI was able to create melodies, and AI could produce instrument sounds. And those were just so interesting for someone like me who was interested in technology and to really see with my eyes its potentials being realized. I often meet with developers, and it seems like they are really benefiting from such technologies. I really enjoy studying more about the field. And with the emergence of ChatGPT, it became the center of attention, and it became a part of the market where there are many stakeholders involved, and there is a bit of a confusion. Developers, unregulated, used to enjoy these new techniques, but now they are coming under regulation related to copyright, so they're a bit thrown off. And on the other side, from the right holders' perspective, or the creators and artists, there's this new tool that appeared, which is starting to create and might be a potential threat to their livelihoods and the roles they play. So this kind of confusion has been seen for the past 2 years. And amidst such evolving landscape, the government tried to find its own role to play, so they launched this working group. And within the working group, I personally was very stressed and was swamped with a lot of dilemma as to how to overcome these issues. Well, the issues were covered by Professor Dae Lee and all of our presenters here, and last but not least, Professor Cha. So there are the issues in the generation stage, and should the outputs be labeled? How should the registration of the works be handled, and the liability of infringement be resolved? I think these issues could be somewhat solved with time as we have discussions and a sort of consensus is built. I have this optimistic view that they will be resolved sometime in the future. But the most urgent and difficult question is how to clear the rights of the training data for the AI models. Director Moon-gi Lee really spoke from the developer's perspective regarding the issue. I often meet with developers and discuss these issues. And one takeaway for me was that government and legislatures, developers hope that the government and legislatures will resolve a lot of the issues, but speaking as a legal expert, there are only some parts that could be handled by the government, which is rather limited. When it comes to property rights, there isn't that much that the government can do. So it is at that juncture where, as covered by Director Lee, we need to look at the market, what should be negotiated and compromised, and how the government could create the platforms or the windows for resolution of the issues. There's a lot of issues related to TDM, and many are voicing the need for TDM legislation in Korea also, as the EU or Japan. Then, if TDM provision is implemented, what can we expect? We can get a hint from the cases of Japan and EU, and I'd like to hear more from those speakers about that. And we are most similar to the US, so the fair use principle will be heavily used at court, we believe, and in the US, usually they arrive at some sort of agreement according to the market forces, and we expect Korea to follow a similar path. But earlier, Darren, in his presentation, said that U.S. government and the U.S. Copyright Office is playing a lot of roles, and until last year, active collection of feedback was conducted, and they're being analyzed, and they will be releasing reports one by one. So among all that is being prepared by the U.S. Copyright Office and the government, I would like to hear more about how they will be involved in constituting the framework and whether they hear any requests for TDM exception. Those are some questions I have for Darren. And, well, Darren is from USPTO. But, well, I heard that he has a lot of colleagues at USCO. So although the reports aren't released yet, I hope that he could perhaps share some projections about what will be included in the reports.
Very well. So thank you for that question. I was hoping we'd start with an easy question, but those seemed like a lot of difficult questions. Let me try and break them down as I heard them from our translators, at least. With respect to the question of whether there will be or one day might be a TDM exception in the United States along the lines of what we've seen in Japan, maybe, or the EU. There is nothing pending right now. There is. I haven't heard of any interest in Congress enacting some type of TDM legislation. That's not to say there aren't a large group of stakeholders that would like to see it or that it would be an imprudent idea. I think in the United States, at least, because we have this long history with the fair use provision in our copyright law, going back well over 150 years, either being there in statute or in some type of case law, you know, the odds of a U.S. copyright system without a fair use provision is almost unthinkable. And so I think there's kind of a wait and see approach among Congress to see how the courts are going to deal with the question of fair use and whether whether it should apply, how it will apply, whether it will apply in different contexts. And I think that question can mainly be answered right now for those who are interested by saying I don't know how the courts will answer, but I think I do know a good way to sort of make an educated guess or prediction in how they will answer. And I think that would be, and you're already seeing this play out with respect to some of the public comments that were received, with respect to some of the initial pleadings in some of these cases, the briefs filed by the parties. It's going to come down to a question of sort of which line of case law is a court or multiple courts going to rely on when confronted with the fair use question. And so you sort of have this, you have a decision from 2015, not a Supreme Court decision, it was a Circuit Court of Appeal decision, the Google Books case. And in that case, you had a situation where the defendant in that case, Google, scanned thousands, millions of books without permission into a database for the purpose of then creating a search function which those books, from those books, which a search function where you could search within the books that were copied. And then in turn, that search function would create snippets that could then be delivered to the users. And to summarize a long history of litigation there, the court essentially held that it was fair use on two grounds primarily. One, that it was, they held it to be a transformative use. And two, importantly, they also held that Google's use in that case did not serve as a market substitute, essentially. And then more recently, 2023, there was the Warhol decision, where the Supreme Court held, kind of narrowed the door a little bit on the transformativeness issue, and kind of held that I think maybe created some uncertainty for AI developers regarding whether using works to train them is fair use, created a little bit of risk for those developers. And what that court basically said was that the new work that was created in that case, one, was not transformative, and largely because it's substituted for the original work in the marketplace. So I think plaintiffs will find it, plaintiffs will try to argue that the AI-generated works are in the cases where they're substantially similar, at least, to the works they've been trained on, are a substitute and therefore not transformative. And so I think I can lay out the framework for you, like, you know, which way is the court going to go? Are they going to rely primarily on that first line of cases or that second line of cases? I think if they rely on the first one, there is a better chance that it will be determined to be fair use. If they rely on the more recent Warhol decision, there's a better chance that it will be found to be infringing. However, I just want to caveat that by saying that that depends on what type of case we're talking about. You know, there's a type of infringement cases based on input. That'll be its own fair use analysis. There is an infringement case based on AI-generated outputs. That's a different fair use analysis. And then a third type of fair use analysis, which would be even more complex than the two I just mentioned, would be secondary cases where there are claims of secondary infringement. So I think I can lay out for you kind of a general framework of where of the options that are writ large before the court, but it, you know, it is anyone's guess right now where different courts might go. You know, I mentioned there's about 30 of these cases pending, so they could go a lot of different ways. You know, and in a case dealing with, you know, an AI model that produces, you know, books or visual works of art and ingests other works in order to produce, you know, produce those types of works, might be very different than, for instance, a case where, say, for instance, a self-driving car company is ingesting thousands upon millions of pictures of stop signs and crosswalks and mommies and daddies pushing baby strollers and bicycles and other things that you're going to want to train that car to you know, stop for. Perhaps there might be, I think there's perhaps a more sympathetic case for it there than there might be in some other cases. Those are just my best humble guesses, though.
Thank you. 역시 이제
Thank you. He's been talking about the U.S. case. So rather than the government taking a proactive stance, the government is waiting a little bit more for the courts to come up with its own ruling on a case-by-case basis. So now let me go to Japan. So let me ask our Japanese speaker.
일본어로 순차.
So I believe that your answers will be consecutively interpreted. As we are aware, Japan recently introduced the TDM exemption, and regarding its interpretation, you have introduced the report, the general understanding that was announced by ACA. With regards to interpretation of the provision, it seemed like there was a similar approach as to the fair use doctrine. So how much of a guide can the TDM exemption give to the developers, which may be even better than fair use? Do you perhaps believe that Korea is at a juncture where it should introduce TDM exemption provision that could better guide the AI developers better than fair use?
ご説明をいただいた日本の、権利制限規定著作権法第30条の4です。フェアユースドクトリンを参考にしたものとなっています。でここでの差を、説明すると、こちらは日本の、法解釈についての考え方が一つ、由来になっています。で日本では、政府が法解釈についてある程度考え方を示さなければ、民間ではなかなか、法解釈が、不確定な部分について、ビジネスするのが難しいといったような声がありました。
네, ここまでにします。すみません。지금부터 일본어로 말씀드리겠습니다. 일본
So, with regards to the opt-out provision, if you look at the Copyright Act of Japan, it was based on the fair use doctrine of the US. So, I will explain how it was formed. In the case of Japan, government provides guideline for legal interpretation, or else it's difficult for the private sector to actually use those laws. To use the provisions for business purposes, the government needs to first provide an interpretation.
権利制限規定が、導入された時も、フェアユースと同じような規定を導入するのが良いのではないかといったような意見もありました。しかし、そういったフェアユース、司法によって、判断されることに委ねるというような規定は、日本の法文化には合わないということで、ある程度の明確さを持った、柔軟な権利制限規定というものを導入することになりました。
2018년
In 2018, when the opt-out provision was introduced, there were suggestions that it should be similar to the fair use doctrine of the US. However, it is a provision that is wholly determined from the judiciary branch, is not appropriate for the Japanese legal structure. So we have adopted a more flexible measure.
フェアユースの中でも、特に先ほどもお話があった、トランスフォーマティブユースの中で、典型的だと思われる例を、具体化して、法の規定にしています。例えば、技術開発のための利用、リバースエンジニアリングのための利用、そして、AI の開発を含む、情報解析のための利用といったものです。
すみません。トランスフォーマーもう一回そこだけお願いします。
トランスフォーマティブユースですね。
ありがとうございます。네, 그리고 이 규정과 관련해서는
And with regards to this provision, among fair use, the element of transformative use was an approach that was adopted. So the use for technological development or the use for reverse engineering and the use for information interpretation by AI were covered under the provision.
このような理由ですので、日本法でもあくまでトランスフォーマティブな利用のみが許されるということになります。そのため、権利者に対して悪いインパクトを与えるような利用ということは AI 開発の、際も、それは許されないということになります。
이러한 이유로 일본
So as such, only for the use for transformative use were recognized under Japan. Any forms of usage that could negatively impact right holders are not allowed in Japan. Even if it is for AI development, if it may harm the rights holder, then it will not be allowed under the provisions of Japan.
を模倣するような利用であるとか、先ほどご説明したような AI 学習用に、データベースが販売されているような場合には今回の権利制限規定は適用されないということで、権利者の利益と AI 開発等の利用のためのバランスを図っているというような規定になります。
예를 들어서
So for example, if you're looking training data and copies of the training data, or selling the database for the purpose of AI. In these cases, the opt-out exceptions would not apply. And so the AI developers and other stakeholders have to seek a balance in their interests. So in some ways, the American fair use doctrine seems to be more flexible. However, if you look at the litigation culture in Japan, there is a need for certain clarity involved when it comes to managing the exceptions. So just one more additional question. You talked about fine-tuning, and it's not applied to the opt-out, and so there is a need for permission from the rights holder. So in the pre-training, what's the interpretation? Is it still not clear? Is that what you were saying?
権利者の利益を害するような学習がどれぐらい想定されるかという問題だと思います。プレトレーニングの段階で学習させたことによってそれが出力の段階、アウトプットの段階で出力されるかというところを考えるとその可能性は低いのではないかというふうに思っています。そのためプレトレーニングの段階についてその著作権法第30条の4が適用されないかというとその可能性は大きくないというふうに考えています。
프리트레이닝.
So in the pre-training stage, the interests of the rights, if it has been deteriorated, then that would be the main factors. But then if the possibility of then output is rather low, so in the pre-training stage, the Article 30 to 34, I don't think has a high possibility of being applied. So now let's go to Europe.
Margoni.
Professor Margoni has a bit of a critical view on the European framework, I believe. So I think Article 3 is not relevant for the industries, but Article 4 is more relevant for the industries. So although the exemption is there, opt-out allows rights holders to reserve their rights, and that is the system in place. In that case, this is a personal opinion, but if you compare it to the U.S. fair use doctrine, do you think it provides a favorable position for the AI developers?
Well, there are a number of variables at play here that should be duly considered, both of a legal and industry and technological nature. I think that what the European legislation has attempted to do through the legislative interventions that I have described is to draw one of the possible balances. And in this specific case, a balance that distinguishes text and data mining for research on the one hand and text and data mining for commercial purposes on the other, giving the possibility to right holders to opt out in this second case. I think it is a quite interesting move. It has a number of advantages because it empowers right holders to determine so to speak, the faith of the use of their works. I give you an example. This, I understand it crosses maybe a bit the line between research and non-research, but a lot of publishers in the EU are contacting their authors, academic authors, asking whether they desire their work to be included into a new AI deal that they're signing with AI companies. And among the benefits of participating, so not opting out, there is an enhanced visibility. So there are many angles, what I want to say with this example, that might favor right holders that do not decide to opt out for monetizing, but decide to stay in, so to speak, in order to reap different benefits. We see in practice, every one of us now has, their app of choice implementing an AI system. Often we use these AI apps, perhaps wrongly, but as if they were search engines. The latest versions implement advanced search engines functionalities that combine both the kind of answer that an LLM would give you, but that at the same time serve the web in real time, and they cite, for example, the relevant literature in order to make their argument better supported, better substantiated. In this case, of course, from many points of view, the fact that your work has been cited in that specific case has an advantage that cannot be measured directly in economic terms. So there is no fee that you gain in that situation, but has obviously indirect financial benefits that are difficult to assess ex ante, but they're certainly present. So I do think that this possibility given to authors, to right holders to opt out is a very interesting feature. As I said, one of the problems connected to that is how to operationalize. There is the issue of machine readability of the opt-outs. There are various initiatives that are being deployed in Europe. The W3C is developing a protocol. Other industry or NGOs initiatives are trying to develop standards that will make that opting out easier and more granular, because you can opt out from different things. Some of them are boosted by an underlying legal requirement, some others not, for example. So the difference between a robot.txt and an AI.txt. But I think this is a conversation that will be, is up now, that at the AI level, at the European level, will to a good extent be driven by the newly constituted AI office. I think that the role of this new agency will become extremely important in the future of this conversation. So I invite you to look at these developments. And then again, very briefly, do not forget all the legislation, the data legislation that we have approved in Europe in the last 5 years, because there is so much in there that does not tackle copyright specifically, but creates new access and reusability rights for data with the specific scope of creating high-quality data sets that market player can use in order to develop better AI, that I think is very innovative in the international landscape. High-value data sets are data sets of meteorological, statistical, or commercial government agencies. Those have to be made available through API or in bulk download under no restrictions to use for any purpose. This is, mandatory. And there are many similar examples. So I think that this is the right angle to see the entire European ecosystem in the terms of good quality data, which I think is connected to some of the points the previous presenters have made.
Okay. 계속해서 연결해서 좀.
So let me continue in addition to that. So Professor Margoni had talked about the Common European Data Space for AI training data.
액세스를 지향하는 이제 유럽.
And there was the trend of Europe towards open access, which I believe is relevant. Then the doctrines that govern open access, are they appropriate to be applied to AI is one question we might have. For example, the CCL license or CC BY or CCSA terms, how can they be maintained in the AI environment? The existing open source or II or these measures, how could they be adapted for use for the AI?
So I think once again it's it's a very good but not so easy to answer question, because there are so many potential variables in the real world application of your question. But I think that, for example, Moon-Kee Lee, the director, has pointed out earlier the need to have at least a level playing field in terms of access to a certain type of data, because if all data is expensive, there is a risk to favoring an oligopolistic market development in the field of AI training, which could put at disadvantage certain specific fields, specific subdomains, specific linguistic groups, etc., etc. So I think that a combination of all these resources, it's a possible solution. And I think that a very interesting approach given by the European legislator in this sense is to create a sort of taxonomy of data access rules. I didn't have the time today, because it would have been even longer, my presentation, to analyze this taxonomy, but we do have it. Again, the example of high-value data sets that I presented, they must be made available under a CC BY license, which I think is quite extraordinary to see a piece of European legislation identifying a very specific license, the one that you have mentioned, in order to enhance access to this high-quality data. But the same legislation has identified special reuse provision for research data, so data that is produced during public research activities. There is, for example, to give you another example, IoT data. The Data Act has created a special right to access and portability of IoT data. So now in Europe, if you own a fridge, before we didn't know who was the owner of the environmental data that the fridge collected, but certainly the manufacturer would have had a de facto and by design control over that data, because they designed the fridge, designed the software, etc. Right now we have a right of the user of the fridge to have access to this data, but also to order the manufacturer to transfer that data to another third party, including a commercial competitor, for a variety of uses, including high-quality data sets that can be used for repairing that fridge, to avoid market lock-in effects, but also to create these high-quality data sets necessary for AI training. So as there is a taxonomy of data types, of access and reusability types, I think there is a need also for licenses like the one that you have mentioned that can favor reusability with the advantage and disadvantage of licenses. The advantage is that they are voluntary, so it is up to the right holder, similar to the opt-out, to decide, with the disadvantage, which is the reflection of that, that they are only as good as people voluntarily adopt them. But I think that these designs designates a quite detailed ecosystem, perhaps a bit complex, but certainly able to capture the different interests of the different stakeholders at play to favor a more rich and accessible body of data to develop better AI.
Thank you. 지금부터는 이제
Okay, so I think we can entertain some questions that we have received from the audience and also from our YouTube channel. So I have an updated list of questions for the morning session, and I'm sure we'll be updated with additional questions later. But so there's a question for Mr. Darren Pogoda. So it's about publication of various reports that you mentioned. So when are those reports to be issued? And then when it comes to AI, generative AI that mimics voice or likeness, is it based on state law or federal law? What's the direction basically that people are trying to take in the United States, state law or federal law? Two questions.
Sure. So I'll deal with the first question first, which was I mentioned that the U.S. Copyright Office is working on a report in response to the public comments it gathered, and that report was going to come out in different sections. So I'm a little bit hesitant to speak for another agency, but I can tell you that everything I said this morning has been stated publicly by the Copyright Office. I don't know the exact dates that the sections of those reports are coming out. What I do know is that they have stated that they wish to have all of the sections released by the end of the fiscal year, which would be September 30th. I know that they are working hard on them, and I know that they are endeavoring to get them out as soon as possible, and that there is great interest in them coming out and reading what they have to say. That is the most information I have for you. I don't have specific dates. The second question, which dealt with name, image, and likeness issues, what in America sometimes is referred to as a right of publicity law. And so, yes, in the United States, it is a mix of state law and federal law. It is mostly state law. And some states have it in statute, like California. Some have it in New York as well. Some have it in their common law or their case law. Some don't have it at all. And the scope of those laws vary from state to state. There is a limited amount of federal law within the Lanham Act. This is Section 43A of the Lanham Act. The Lanham Act is America's trademark, the national trademark law. And so there is some stuff in there that overlaps a little bit with some of the state law, but it is not a comprehensive federal scheme. And so as a result of some of the recent, capabilities of AI to reproduce famous persons and non-famous persons alike, their name, image, persona, other characteristics of them with amazing accuracy. There has been a lot of interest in Congress and in studying some type of federal scheme that would apply nationally and apply a little uniformity to that law. I will say one of the key questions, and it was a question that was actually asked in the Copyright Office's notice of inquiry, where they put out those 34 questions I mentioned with all the subparts. One of the key questions there will be, if a federal scheme is proposed and then eventually enacted, would it preempt, and that's a legal term of art in the United States, would it essentially override state law, or would it act somehow in conjunction with it? And so that is just sort of a little context on how that law operates in America, and how we are currently studying different options for perhaps maybe making adjustments to it.
And one more question for you. And
So regarding the registration of AI output, is there new issues that lead to a new compendium or revised compendium? Is that how it happens? So this is a question related to the copyright compendium or copyright registration compendium. So if that's the case, so if new issues led to a new compendium or revision of a compendium, what kind of issues were there, and what were some of the revisions, the new directions that had come out from the registration?
Sure. So for anyone not familiar with the term compendium, the compendium is a formal document, for lack of a better word, or maintained by the United States Copyright Office that deals with Copyright Office practices and policies. A lot of those deal with registration, meaning applications to register copyrighted works before the office. I don't know whether the new policy statement that was issued in 2023 with respect to AI-generated works was officially incorporated into the compendium, but the compendium is a living document that is subject to periodic revisions and evaluations, and then published anew in its new form. So my honest answer is I don't know if there were any changes made to the compendium, but I do know that sort of when people started trying to register AI-generated works before the Copyright Office, that was sort of the first time the United States, as a government, was kind of forced to deal with the issue of copyright in AI in more than a theoretical sense. They had these applications pending before the office. They had to deal with them like they would any other application, and so making just an educated guess here, but I think the Copyright Office was making its honest best effort to get out, if not in front of the situation, at least alongside it as best they could when confronted with just the latest issue presented by artificial intelligence and its intersection with AI.
마르곤 교수께 드리는 질문인데요.
Now, this question is directed to Professor Margoni. When there is a copyright infringement, it seems that it will have to follow the laws of the country where the infringement happened. Do you believe that a GENAI-related provision could be added to the Berne Convention?
Well, to take a shortcut, no, for practical reasons, in the sense that we haven't been able to change the Berne Convention for many decades, so I think it will be unlikely. It could be possible, and I think that maybe here I'm talking more as an academic than as an international corporate scholar or advisor. The idea of an international instrument that could harmonize at least a baseline of the main rules is possibly one of the few ways to create a level playing field. I must say that I don't see that happening in the short term, but it could be possible to imagine a situation, and in fact, to a certain degree, it has already happened, it is happening, that various regional or sub-regional institutions or groups are tackling specific aspects of artificial intelligence. Another thing that the AI Act does, however, that I think it's relevant for the question, is to require that essentially if you want to enter the EU market, even if all corporate relevant activities take place outside of the EU market, you have to abide by EU laws. Now, this to me is quite surprising. It will be interesting to see how it can be operationalized, but let's assume for a second that is good and enforceable. It would mean that ChatGPT or any other model based, let's say, in the US, when entering the internal market, have to disclose through a sufficiently detailed summary their training material. Now, if this happens, do we think that the future will be one where OpenAI communicates that only to EU-based operators and not to US-based operators? I think it's unlikely. I think that it's unlikely that two different models will be developed. We have heard how much it costs in terms of money, in terms of environmental costs. So I think that one of the elements that one could imagine there is, we refer to that sometimes as to the Brussels effect, something similar to the GDPR. So the GDPR is European law, but has served in various ways as a source of inspiration also for the data protection laws of other countries. I don't know, I can speak only as an academic, but I clearly see the advantages for a government to have their own standard becoming the international standard. So this could be also an area where our attention has to focus in the future, because if we take the letter of the law as it is written, it will be quite interesting to see how AI developer will comply with this specific provision.
Can I just offer an alternative approach to fixing the Berne Convention as a way to harmonize some of the activity that we're seeing in AI development? What I'm seeing now across industry actually is a need to harmonize an approach to respecting an opt-out. And so I think that ultimately would give you that global solution where content creators can control their level of participation by harmonizing. And I think it's very important that these approaches to opt-outs are clear, they're harmonized. They're not, efforts to kind of just have something hidden on a website or maybe by email, but actually the industry and content creators standardize around an approach, and then essentially you do have that global solution.
So, 오후 세션에 대해서 한 개의 질문을 받았는데요.
We have one question about the afternoon session, and it is directed to you, Sonia. This question was in English. So the question goes, in certain categories of art and writing, economic disruption is being observed, but in fact, copyright law might not be the right tool to deal with those disruptions. Then when it comes to the economic disruption caused by GENAI, what would be an alternative tool or policy intervention that is apt for reducing the impact?
Thank you for the question. Yes, I did mention that in some cases there might be economic disruption caused by generative AI and that copyright isn't the right tool. I guess firstly, assessing the economic disruption is important and taking an evidence-based approach. I think there are lots of concerns about how generative AI could actually have an impact without doing that evidence-based assessment. What we're seeing now actually is there are lots of anecdotal reports that we're hearing to say that actually generative AI is creating more of an uptick in some of the work that was actually at risk or at perceived risk of being affected by generative AI. So, for example, there's a paper that was published very recently to show that Wikipedia's access to those pages has been positively impacted since 2022, which actually was something that was doubted initially. We're also hearing that some journalists are using generative AI to create summaries, and those summaries are actually creating more engagement with the article once those generative AI summaries have been created. So I think firstly we need to consider what the economic disruption is. But then when you do consider the types of challenges that might happen, and jobs probably will change as a result of AI to some extent, we need to think through what the right tools are. I think there is a fallback to copyright as being the only solution, and particularly looking at ways of monetizing training data as a way to compensate for any impact. But I think what you don't have is a win-win situation. I think what you want to try to build is actually more of a win-win situation where people are adding value to the entire ecosystem rather than taking things away. And so there potentially could be different business models created where you could have rights holders maybe preparing their data for AI training in a way that adds value. But also we're seeing different types of legislation, for example, in supporting journalists, where there could be an impact on local news, say, for example, where some of the search and the snippets that are displayed are perceived to have an impact on local journalism. And so there we've supported legislation that actually remunerates journalists. So I think similar approaches can be taken. I think the risk is that we see copyright as the only tool, and then we start to change the parameters of what copyright actually protects. And I think fundamentally what we can't let happen is to stretch copyright so that you suddenly find that you can't analyze data. Because if you look at the definition of text and data mining in the Copyright Directive, it's very broad. It's far broader than any AI training. And so the scenario that Thomas talked about earlier in relation to analyzing data to understand COVID and what was happening there, all of these things will be impacted if we're not careful. So I think we do actually have to approach this very carefully, think about what copyright should and shouldn't protect, and then build on that, and then separately see what other impacts, both positive and negative, there are, and address those in a way that makes sense, but don't see copyright as the only tool.
제가 받은 이 발표.
So these are actually all the questions that I have received from the staff. So are there any questions from the floor towards our speakers here on the stage? If you have a question, please raise your hand and we'll deliver a mic to you.
예, 마이크 뒤에.
예, 아까
So Mr. Moongi Lee talked from the industry's perspective and about the TDM exceptions and the need for the TDM exceptions. He had recommended that we in Korea adopt the TDM exception, speaking from the industry's perspective. If you look at the Korean Copyright Act and any revision bills that are pending, what's the overall attitude towards the TDM exceptions? What's the consensus regarding the TDM exception in Korea?
그대로. 제가 이렇게 대답할 처지가.
I'm not sure if I'm the correct person to answer that question, but first of all, regarding the TDM exception, you have before ChatGPT and after ChatGPT, there's a huge difference. As I said before the revision bills regarding the TDM exceptions, for example, you have one that came out in 2021. The TDM exception was recognized very broadly, including even commercial purposes. Businesses and developers and service providers alike were dealt very favorably. But then after ChatGPT, a big change happened. There were a lot of thought that went into why the TDM exception was not recognized or adopted. That's because people's perception had changed. People were very taken back by the level or the capacity shown by ChatGPT. I'm not sure if this kind of analogy would be appropriate, but Mike Tyson had once said, so until you reach the top, there is always like a plan. So if TDM exception is adopted even for commercial purposes, then the rights holders will inevitably face a situation whereby their works will be used very broadly without any kind of remuneration or reward. Even the opt-out right wasn't certain that it could be upheld. So after ChatGPT emerged, the perception of the rights holders towards AI output changed drastically. And then in the United States, there were many litigations that were filed, or not copyright litigations alone, but class actions and other kind of litigations regarding personal information and privacy. So then in Korea, from the perspective of rights holders and data owners, they started to think that ChatGPT should not be left without a leash. And that seems to be the foundation of the consensus nowadays. And that has also impacted the academia as well. So before the TDM exception, the consensus over TDM exception was that broadly it should be accepted, but after ChatGPT, it narrowed down. Many people started to think that it would unduly disadvantage rights holders. Why should right holders sacrifice themselves so much just for one particular industry, namely the AI industry? That seems now to be the consensus in Korea. So the TDM exception for now is being led by EU. Maybe in Korea, for non-commercial purposes, the TDM exception may be legislated, but not probably for commercial purposes. I don't think the rights holders would allow commercial purposes to be included in the bill pending in the National Assembly. So that's basically my take. So like I said, even in the academia, there's been a change in perspective. There are many people becoming more negative towards allowing TDM exceptions for commercial purposes.
예, 시간이 이제 거의
We are nearing the end of the session. So, well, we are all from the law sector, but we have one panel from the industry. So, after listening to all of us, if you have any additional comments, your last words, then please, the mic is yours. I'm not sure if I have a special comment.
더좀
Let me just say one last thing about the TDM exception. So I'm from a tech company and we respect copyright. I all agree. However, we would like to focus a little bit more on the fact that there are many registered works, but there are also non-registered works as well. So I think we have to find some sort of a solution for the non-registered works. So if there are works that are not registered, so blog contents from internet communities, etc., those are not registered. It's not up to the decision of the service providers, nor up to the individual rights holders. There's no agency to act on behalf of those individuals. No one can make a decision on behalf of those individuals, and nor can we just approach each and every individual. So realistically speaking, there is the technological need and the demand for information and data, but there is no legal process or legal method of approaching and using that data. So I think we need some sort of a legislation to make that possible. So I think we need some sort of an insurance. So even if we do use the data, we won't get into trouble for it. That seems to be the main stance of the industry. Thank you.
해서
We heard your comment, and the government will continue to listen to feedback from the industries and foster continued communication to arrive at a wise resolution for the issues that we are facing Today's Seoul Copyright Forum brings together the AI companies and the copyright experts to deliberate on how to arrive at a balance. And we heard many presentations and we had this discussion. And to speak from my personal experience, I think this goes beyond the realm of copyright. The creator ecosystem and copyright is only a part of the picture. In fact, I tried many experiments, including I took the PDF files of the presentations, I gave it to the AI and asked it to give me some questions that must be asked. And in fact, AI has so much more potential that goes beyond our imagination. It could impact career paths of us and our future generation. So regarding societal issues raised by AI should be discussed, and I hope we will have many more occasions where we could do so as we did today. So this closes the panel session. A big round of applause for our panels. Through the discussion, I think many questions relevant to the presentations were covered. We could tell that different countries and regions have similarities and differences in their approaches to similar issues that are being faced. I'd like to thank the moderator and our presenters for leading a wonderful session. This brings us to the end of all the programs planned for today. I'd like to thank all presenters and all virtual and on-site participants for staying with us until the very end. This closes the Seoul Copyright Forum 2024. Thank you for staying us throughout the heavy and rich program. I hope to see you all again in next year's Seoul Copyright Forum 2025. Thank you.